Sir. Lordship, in regard to the victim compensation scheme, my lord, and another issue is about my lord, state government has taken a cabinet decision pursuant to my lord dispose of the cases which my lord punishment up to 3 years, my lord. But it shows that the object of that both has not been complied with in real terms, my lord. My lord, I have filed through PR, my lord. I pray that this matter may can be taken up Tuesday, my lord. Some urgency.
Not on Tuesday. 24th. Regular day. Regular.
Otherwise, 25, my lord, Thursday.
Not on Thursday. Have it on Monday, Wednesday. Not
My lord, 24, my lord, 20.
My lord, I have also a similar year, my lord, for listing new matter, my lord. A writ appeal, my lord, two writ appeal, my lord, in connection of a payment, my lord, judgment, my lord. And this, my lord, regarding settlement of market, my lord. My settlement, my lord, has been, my lord, set aside on the ground that, my lord, a clause of the NIT, which has been, my lord, stated by another coordinator.
was not pointed out before the last single.
Yes, it was, my lord, and it was, my lord, NF with the restriction, my lord.
That NIT was stayed.
Yes, my lord. The clause of the NIT, my lord, was stayed, and it is annexed with the restriction. Even that, my lord, one organized the, my lord.
When did you file?
My lord, starting, my lord.
You make a mention if it is not listed for Wednesday. You make a mention on Tuesday. You see whether it is listed on Wednesday or not.
It will also, my lord.
Because
Read appeal, my lord, there is some time defect.
you make a mention on Monday.
Obliged.
Maybe. I make a mention for Lordship. You filed an addition deputy, my lord, in matters item number 13, my lord.
1-3.
Yes, my lord. Obliged.
May I please, Lordship? Also, I'll back to mention one mention memo regarding listing of WPC also. It's regarding spouse posting. Last occasion, it was listed on 10th of January, but due to respondent counsel, he could not obtain some instruction from the department. So it was supposed to be listed after the Bihu vacation. So your Lordship may kindly be taken up on 24th, your Lordship. Obliged.
Inform the other side.
Yes, sir.
Lordship, I like to mention item number 10, Lordship. I need some accommodation for today, Lordship. Next day, I need it, Lordship. Item number 10, motion. Deeply obliged.
May it please your Lordships, I beg to mention item number 25, Lordship. My senior is not available today, your Lordship. His father-in-law has expired yesterday. So kindly the matter may be taken after 2 weeks. Lord. Obliged.
Yes, Ms. Ghosh.
May I see your Lordship? I seek Lordship indulgence for accommodation of the day, item number 5, Lordship. Because there's a personal inconvenience. Deeply obliged, Lordship.
My plead, your Lordship. I would like to mention item number 8 for adjournment, your Lordship.
Why?
Due to personal inconvenience of the English council, your Lordship.
Weeks. Next week. Yes.
Advise, your Lordship.
Let me see, Lordship. Lordship, I have to mention number. I have to item. I beg to Lordship.
Which item?
I beg to mention item number 29. Lordship. Let the matter maybe listed after 3 weeks.
Yes, next.
Lordship, your Lordship has allowed listing of a retail list today, Lordship. May kindly be taken up after the motion or update as per Lordship convenience. It is item number 45 in the supplementary admission.
Why? The first case.
Yes.
We'll see. We hear. Yes, what's your prayer?
I beg to mention item number 42 for upgrade, your Lordship. It was listed last, today is the 6th time it was listed, but it was not reached shortest of
In
time.
the second half,
Yes, sir. Obliged, your Lordship.
inform the other side.
Lordship, the records are here. Lordship had asked us to produce the records. It's a video.
By the police.
Pursuant to the order dated 11/01/2024. Ms. A. Verma, Learned Standing Counsel from Department Assam, have placed the records of FT case number 728/2016. That was disposed of on 18/6/2018, the learned member, Foreigners Tribunal number 9, Gurgaon. Full stop. Place both the matters again on February 6th. The records of the FT case number 728/2016. Placed before the court today by Ms. Verma. Be kept with the records of WPC number 1244 relating to WPC number 1244/2000. Be tagged with the same this record.
Public.
Lordship.
Yes.
Here, petitioner want to withdraw the writ petition. It's per the instruction of the client.
You have the instruction.
Yes.
You have an interim. Lordship, if there is an interim, it should ought to be vacated, Lordship.
If there is any.
Yes, Lordship.
What's your good name?
C Talukdar. On
Yes.
be-
Full
C
name.
Sandan Talukdar
You are appearing on whose behalf?
on behalf of ALA. Lordship. And also the item number 4 also with me.
One by one, one by one, don't say together.
Mr. Sandan Talukdar, Learned Counsel. Third, Mr. Sundan Talukder, counsel appearing on behalf of Mr. Ahmad Ali, Ahmad AHAMMADL, counsel for the petition. Also heard. No CGC. Ms. A. Verma, Standing Counsel, Home Department, Assam, for the respondent number 2 and 6. Mr. P. Sharma. Yeah. Mr. P. Sharma, Additional Senior Member, Assam, for the respondent number 5. You are appearing for whom? Election Commission. On behalf of Standing Counsel. Mr. Sitalogda, Learned Counsel, appearing on behalf of Mr. A. Counsel for the petition on instruction submitted that petitioner is not facing this petition, which the learned counsel for the respondents have no objection. According. By this application filed on 28/06/2019, the petitioner prayed amongst others for a direction to the Foreigners Tribunal number 2 Nalbari, so as to allow him to submit his additional written statement and additional evidence on affidavit, as well as further evidence in FT case number FT within bracket NAL-2 numerical 2 bracket close, case number 106/2015. That is pending against him, as well as the order dated 10/06/2019 passed by learned member of Foreigners Tribunal Nalbari, Foreign Tribunal number 2 Nalbari, in said FT in bracket and case number such and such, rejecting the petition number 475 of 2019 filed by the petition. According to this, dismissed being not pressed. Some order. CUC 1, MSA Burma for 2 and 6, P. Sharma 5, L 3. Petition number 387/2019. Order date to Likito. 0405/2000. FT Nalbari 2, case number 133/2000. Same order.
Equally obliged.
Appeal, Lordship.
Abdul Manan.
Here is my lord. One case is ex parte, my lord, and one is contested case, my lord. My prayer will be, my lord,
6 to dear, no?
ex parte order may be set aside, and a second case is, my lord.
Which is the second case?
My lord.
Which is the second case?
Second case number, order is 59, my lord. . SPP 9. This is a contested case.
Party order against the to never change the protocol. Contest होते हैं अभी party order. Party Scotland 53 56 53 39.
List along with the records of WPC number 3823/2016 disposed of on 23/06/2016. List complete.
Lordship may call for the LCR lordship.
Let us see, because the first case which is talking about, there is an order of the High Court
Yes, lordship.
placed on 24. Or make it 29th.
29th of this month.
Placed on 29th, along with the records of disposal of.
WPC
Well, in this case, the Education Department Council was asked to obtain instructions on the transfer certificate which has been relied upon by the petitioner, page 67. There is an order dated 28/8/2023. She had relied upon the school certificate, and along with the voters list of her father of 1966, 70 and or.
Police notation call for the record. In the
Yes,
meanwhile, what they are doing. Third, Mr. M. Rattal, and counsel appearing for the petition.
WPC
And I'm at the Ireland and TGC for the national number 1. Also heard MSA Vermal and extending counsel from Department of Assam for the national number 2, 3, 4. 2, 3, and 4. And Mr. AIL extending counsel. Elections region for the national number 6. On a reference being made by the Superintendent of Police Board. No. Being FT case number 1638/2009. The learned member for next tribunal Nagaon 10th at Sankardev Nagar Patai. In FT within bracket T case number 1328/2015. By the impugn order Nagaon 10th by the impugn opinion come final order the 28/02/2022. Appoint the petitioner to be a foreigner under the Foreigners Act 1946. Who had illegally entered into the territory of India within bracket Assam on or after 25/03/1971 from the specified emergency without having permission. To satisfy with the said opinion dated 28/02/2022. Petitioner has filed this declaration 09/03/2023. So notice returnable. Right. It is called for the records. Appear before the Superintendent of Police Board. Judge, Judge, honor before 3rd of February. Condition. Place this matter for admission.
The Lordship is given protection, interim protection.
3rd of February, appear with.
My deep love, the Lordship.
3rd of February.
Yes, what is the status?
My Lordships, in this, I want some time, my lord. We are already communicating with DGP. DGP sent a letter to SP, my lord. SP again sent that Hojai police station. And Hojai police station called this petitioner in police station. And my lord, that report we have not received. Another 10 days time, my lord.
Give us a date, Mr. Sharma. We'll consider. Yes, what is your instruction?
I have written how to that passport has been issued, madam. Really, but that is an.
Purva.
It is kind of temporary. Sorry, no. No, I have no. Apply for the
8 February. 8 February. 9 motion they have.
9 full time.
SP দিব আৰু নহয় এইবিলাক মোচন
কপি আছে নেকি? Yes.
new 2021.
Now, Ms. Gayan, just tell us,
Yes, ma'am.
the Tatkal passport issued to the petitioner,
Yes, ma'am.
still valid? Right, in spite of the police report forwarded to you,
Yes,
to
madam.
the Minister of External Affairs,
Yes.
still valid? You have not taken any action.
Yes.
When the police have also reported that the person concerned who has applied for is not available in it,
Yes, madam.
not to be found in the address given there.
Yes, madam.
How come that passport is still valid?
My lord, that is in the third para, my lord. The address for which the respondent for applicants pending on as on that. My so-called notice was issued, my lord,
Then
on
what happened? That is in 2022.
22, my lord. Yes, my lord.
We are in 24, already 19 days is over.
Yes, my lord.
So what action you have taken? That report was of 2022.
22.
And since 2020, you are sitting idle. And that person who is a foreigner, as of now, the matter is pending before the sub judice.
Yes,
But
ma'am.
no decision has been taken.
Yes.
It is not in favor of the petition. So till now, that particular Tatkal passport is valid. And the Ministry of External Affairs, when issued Chopa's notice in 2020, it was in March 2020.
Then-
Sitting over the matter, allowing a foreigner to roam around or do anything of his kind.
My lord, but my lord, address, the adverse remark is that that application does not reside in the
Then,
given.
then why you have not cancelled that Tatkal passport issued to the petitioner? See, so many things are now unearthed. We do not know what you are doing. We thought you are safeguarding the nation. In this way, you are safeguarding the nation. Look at the conduct. March 2022, so-called notice was issued. Until then, you have not acted upon it to cancel the Tatkal passport issued to the petitioner.
That-
See, it is your document.
Yes, my lord.
It's not Gayan's
Yes,
document.
yes, my lord.
But the department has done it. And
Yes,
see,
my lord. No action has been taken, my lord. The application is pending as on
So-
there, that is, my lord. Instruction is there.
when there is a specific police report that the applicant who applied for Tatkal passport was not available in his address at all,
Yes, my lord.
then if you give this kind of Tatkal passport without any due verification, any ABCD can apply and get it.
Yes,
Leaving aside that he was declared to be a foreigner.
yes, ma'am.
The person concerned is not available in his address given in his Tatkal application.
Yes.
In spite of that, you have considered.
Mhm.
And we do not know what kind of verification was done in the previous application while granting him the passport,
Yes,
the
ma'am.
previous passport. Tell us what we should do. You tell us as a court officer, what should
Yes,
we do?
ma'am. My lord, that is, I'll produce the record on what basis they,
Producing the record is not sufficient.
but what they have.
You have received, you have issued a Tatkal passport
Yes,
to the
my lord.
petitioner as per this report.
Yes, my lord.
Police found, the
Hmm.
local police found that application from which the petitioner applied
Hmm.
is not available in that address, is not a resident of that address.
Yes, my lord.
In spite of that, we are allowed to continue. We have issued a so-called notice on March 2022
Yes, my lord. That
and
is,
sitting idle over the matter till now.
yes,
Why? Almost 2 years, 2 months, right?
Yes, my lord.
So 1 year, 2 months. How come you do that being a Ministry of External Affairs? Everybody is involved. When the IB is involved, all departments in the previous letter you have placed.
Yes, my lord.
Everybody was involved.
Yes, my lord.
So how can you do that? We do not know. This is only one case.
Yes, sir. There may be lots of.
Thousands and
Thousand.
thousands.
Yes, ma'am. That may be.
Right?
Yes, my lord.
We do not know anything. Why?
My lord.
Get hold of Mr. R.K. Dev Chaudhary.
Yes, my lord.
Get hold of him.
Yes,
We'll
my
take
lord.
it after some time.
Yes, my lord.
It's not a threat to the nation. Yes, Mr. Rahman.
My lord. Ex parte order, my lord. Page number 20, my lord, impugned order. 19 actually. Relevant portion 20, my lord. Second para. Because of pandemic, my lord, she couldn't appear, my lord.
Aditya pani fix asile. Kuni sigami record dito. Because she came after 19, she did not approach the court.
Yeah, 21.
No, she got her opinion is of 21. She's in detail. Recording. One pending case, 19 case, judgment 21. Ex parte order. Ex parte order that will be elaborated. That's ex parte order, no?
To the next part,
She never appeared.
you appear, she was filed everywhere.
But she did not.
Because of pandemic.
Pandemic, we took out that notification the other day. The notification to what in pandemic.
Mr. Raman, take your.
My lord, thank you.
Notification मारनी है.
Notification. Okay.
Each party to like sufficient time, sufficient time. Yes, Lordship. Yes.
And we found that after the notification of
COVID.
the tribunal court that was passed by High Court on 4th of September
September.
2021, the matter was soon to be placed before the tribunal on 4th of September 21 itself. And after basically 18th of March 2020, because of COVID and others, though the tribunal took up the matters, the procedure was not before the court. So after 18th of March 2020, the date on which the prosecutor filed her written statement, she was supposed to submit her evidence in affidavit. Now, since then, because of the COVID, the prosecutor could not appear, did not appear. So after the reopening of COVID, though dates were fixed, the proceeding was probably not aware. No notice was also issued, press notice was issued, and the proceeding also did not take any steps. What happened with regard to her, this matter. But ultimately, when she was taken into custody, detained in the detention center, she has filed this petition. In the meanwhile, there is an ex parte order. What sister is telling, the court asked that on being normally, while she was looking after the matters, after the COVID period, notice were issued to, because there was a long gap. Here
Fresh
that procedure
notice,
hasn't been
fresh
followed.
notices were sent out.
Because the procedure will not be aware only the next date. So there's a long gap from 2020 to 2021, later part of it. We're inclined to
Remand back.
set aside the matter and to remand back. Sister will pass the order, and accordingly we'll do that.
Accordingly, a bail order will be passed. She has to appear before the SP of the concerned.
My lord, my lord.
And thereafter, after the bail order, after her release, she will appear before the tribunal
My lord.
by 8th of February.
8th of February.
8th of
My
February.
lord.
And on that very day, she has to submit her evidence and affidavit.
My lord.
And
My,
there will be a direction that the matter will be disposed of.
my lord. My lord. Keep it up.
Administered AW also preparing.
You don't mistake it.
I'll personally monitor.
MS. Learn it to the seaport restaurant. Mr. AI Ali, Secretary Council, Election Committee, Correspondent. MS A. Verma, Secretary Council from Department of Assam, for the respondent number 3 and 5. Mr. P. Sharma, Additional Senior Government Assam, for respondent. Election.
Hmm. बताओ वाली किसी को बोलो। अच्छा, एक मिनट।
IPL. The expert order. 29, 10, 22.
Must be the vacant.
Set aside. Remand for last time. Also, application. Also.
Lordships, the record may be handed over
Yes,
to
yes,
us.
it
We'll
will be-
send it back.
we
We had
will-
produced the records.
Hand it over. MS Hayward. Standing counsel. What is the-
DP obliged.
Yes, Deputy, have you gone through the note?
Yes, Lordship,
See the,
I have seen Lordship, once
how
the,
such kind of inaction,
this
the entire
cannot
nation
be
is in
allowed,
threat.
Lordship. He may not have been declared a foreigner by any authority, but he is not found to be in that address.
That is what is more,
So, Lordship,
this kind of things we do not know.
Lordship, there may be other cases as well.
This
In
is not,
Assamese, there is a word kesu khandote half. You are aware, right? So this is a case
Yes, yes, yes.
from
It's
where
a
to where it
typical
has
case.
been linked.
Yes, Lordship.
And the Ministry of External Affairs,
This,
Information Bureau, all fail.
mm,
You
this,
don't know how many cases, maybe thousands and lakhs.
Lordship, but since Lordship, this has come to notice, Lordship, I would take it up with the authority for doing it. Because they cannot sit over it. This report has been submitted in 2022 itself. 31/3/2022 report has been submitted by the police. And a show cause was issued on 5/4/22. That is more than 1.5 years, Lordship.
but Lordship, this is not true, Lordship. I am permanently residing in that place, Lordship. If I'm not residing that village, then how they can issue passport in favor of the Lordship?
So that is why, Lordship,
And
the
your
show cause has not been replied, Lordship.
Yourself, they have not sent any show cause notice to me, Lordship. If they already sent to me notice that, Lordship, then I would appear before that, Lordship. Your Lordship, this is the, your Lordship, kindly see. Your Lordship, police verification is not required, Lordship, for renewal of passport, Lordship.
Post
This is-
verification is required, Lordship.
Post
but
verification
it's-
already done, Lordship.
No.
No.
This verification is required.
But you see, here is the proof for renewal of passport, Lordship, before the expiry of
Passport, I think.
Have you applied for passport?
No, Lordship, but this is the result.
You're wrong. During the deliberation of the matter, it is placed before the court that The petitioner, Mohammed Ibrahim Ali, was first issued passport number B0134537 with date of issue 07/07/1999 and date of expiry was 06/07/2009. Later, Said Muhammad Ibrahim Ali, the petitioner of present case, applied for passport, white file number, all capital, GUWA 00689412, applied for passport on 15/02/2012, white file number GUWA 00689412. And his said passport application stood closed because of shifting of passport application system from legacy L capital within bracket NIC system to new online passport seva project PSP capital within bracket PSP system. Since there was a clear police verification report within bracket PVR already received in favor of the petitioner from police for the manual passport application, the petitioner was given the opportunity to apply online in the new PSP system. And his application was processed on within colon gratis basis as per extent deed and guidelines. Subsequently, the petitioner on 07/11/2012 submitted online application for passport with application number GU 10606537650012 and passport was issued to him file number K 1151290 dated 07/11/2012 and its date of expiry was 06/11/2022. That was issued to him on gratis within colon and on the basis of earlier clear police report. Next. On 29/01/2020, the petitioner again submitted online application for reissue of his passport with application number GU 107460823580. Though the date of expiry of his passport was on 06/11/2022. Petitioner's fresh application for passport on the petitioner's said application for passport dated 29/01/2020 was processed and was granted to him on post PV mode as per rules. White passport number U2457518. White dated 30/01/2020, and the date of expiry of the said passport is 29/01/2030. While police verification report for his previous passport number U2457518 dated 30/09/2021, that dated 30/01/2020, was pending with police authority. The petitioner again submitted an online application for reissue of his passport under Tatkal category, T capital. While application file number GU 10756012662221, along with his old passport, copy of PAN card, copy of bank passbook, and declaration for conversion from immigration check required within bracket is here to immigration check not required, based on period of stay abroad. His earlier passport number U2457518 was cancelled, and his Tatkal application was granted on post PV mode as per rules, and new passport number V1732844 with immigration check not required. Mr. Chaudhary,
Yes.
see the fund. And it was issued on 03/09/2021 with date of expiry 02/09/2031. Later, on 27/12/2021, police authority submitted an adverse report with regard to the petitioner, with the remark within colon, non-appearance, any capital, of the applicant despite informing him / her, close colon, for his earlier passport application file number GU 107460823580 with passport number U2457518. As such, so cause notice by reference number SCN /319076496/22 dated 03/01/2022 was issued to the petitioner, followed by reminders, while later on the reference number REM, all capital, 3221-60878/23 dated 02/02/2023 to his given address. and both were unrepresented. Further, on 31/03/2022, Police Authority again submitted an adverse report with the remark within colon, adverse due to the applicant does not reside in the given address. Colon close. For his passport application file number ZU 1075601. Further to break. Very good. Paragraph 40. GU 1075601 266221. Within bracket. Valid passport number. Which passport number? Remand 5 but V 1732844. And for that, the office issued a so-cause notice to the petitioner, while later reference number SCN/319694724/22 dated 05/04/2022 at his given address. But the response from the applicant since then is pending till date. In a reference case, in a case referred by the Superintendent Police Border, Nagaon, right, case number FT/H/2471/2012. In spite of service of notice as per the Ordinance of the 1964, the petitioner did not appear before the Foreigners Tribunal, And accordingly, learned member Foreigners Tribunal Hojai Sankadev Nagar by order dated 08/12/2016 in case number FT/H/2471/2012 by an expert order 08/12 declared the petitioner to be a foreigner under the Foreigners Act 1946 who had illegally entered into India on or after 25/03/1971, informing the Superintendent of Police Border Hojai for taking necessary follow-up action and forwarded a copy of the said order dated 08/12/2016 to the Superintendent of Police Border Hojai for his information and necessary action pertaining to his reference case number FT/1322/2010 dated 11/08/2010, wide number FT/H/2471/2012/82 dated 23/12/2016. It is very surprising that in spite of the fact that in spite of the adverse report against the petitioner submitted by police, and so cause notice being issued on 03/01/2022, followed by reminder on 02/02/2023, and further so cause notice dated 31/03/2022. The Ministry of Home Affairs, as well as the Ministry of External Affairs. Is it External Affairs?
Yes, Lordship.
Home Affairs in the Foreigners Division. Ministry of Home Affairs, the Foreigners Division, Union of India, as well as the Ministry of External Affairs, are sitting over the matter since January 2022, as noted above. And without which we found that without due verification, the External Affairs Ministry in Union of India and the Foreigners Division, Foreigners Cell of Foreigners Division, Foreigners Division in the Ministry of Home, Union of India, sitting over the matter, illegally issuing in the issue of illegal issuance of passport and Tatkal passport to the petitioner. That too within colon immigration check not required. Who has been declared a foreigner on 08/12/2016 by the Foreigners Tribunal, Ozai Shankar Devnagar, on 08/12/2016 as noted. This itself, the action of the Foreigners Cell in the Ministry of Home Affairs, Foreigners Division, and the External Affairs Ministry in and of India itself is a threat to nation, granting threat to the nation. Such kind of passport, that too, without immigration check not required, who is declared as a foreigner, to a person who is already declared as a foreigner. List on 8th of February, enabling the Foreigners Division, Ministry of Home Affairs, Government of India, as well as the External Affairs Ministry, Union of India, to apprise the court regarding the action taken report with two the declared foreigners in illegally issuing passport, the declared foreigners, including the petitioner, illegally issued without proper verification. Considering the same to be a threat to the security of the nation, as the Supreme Court. Please take your seat, Mr. Chau. Proceedings on topic of Assam. It is to be noted herein that the Honorable Apex Court, in the case of Sarvananda Sonowal versus Union of India, within bracket 1, reported in 2005, 5S665. After considering the IB report, categorically observed that the state of Assam is facing external aggression and internal disturbance on account of large-scale illegal migration of Bangladesh nationals, and therefore it is the duty of the Union of India to take all measures for protection of the state of Assam from such external aggression and internal disturbance as enjoined in Article 355 of the Constitution of India. Aforesaid action of the Union of India in the Foreigners Division and the External Affairs Ministry clearly reflects their failure to protect the state of Assam from such external aggression and internal disturbance as provided in Article 355 of the Constitution. List on.
Lordship, may I pray, Lordship, my name may be reflected in the.
Pardon, Mr. Architect. Copy of this order to Mr. Architect London, Deputy Solicitor General of India. For if necessary. The report submitted by London Deputy Superintendent SGA before the court be kept as a part of the record.
All right.
Yet, legal answer. In this case,
So what happened?
my lord. My lord, petitioner filed written statement and also adducing her evidence in chief for affidavit, and certain valid documents were also been exhibited, and with a linkage certificate, but that was not considered by the. And this case, my lord, record may be not LCM may be confirmed.
Which is your link document?
Link documents, my lord. First, my lord, they are in my lord Morigao district, my lord, Nagaon, my lord, and due to in 1965 voter list, my lord, his grandfather is there, and grandmother is also there, my lord.
Then we're asking which is your link document?
Link documents, and thereafter, my lord, on Gaubras, my lord, by the Morigao, my lord. This
Page 29.
Which page?
Page
29.
23.
29, Lord.
23, and thereafter in 29, my lord. And marriage certificate 28, man. And 29 is the Gaubra certificate, man. Teenager, she was married, man. His father, as well as some others were also given evidence, man. That was not considered, man. And she also gave written statement. And evidence in chief. And DW witness also there.
What is his evidence? The Gaura.
Gaura evidence is not there.
So this document is not proved.
Not proved. It's my problem.
And
And others are father as well as my lord DW. They are
what
given.
about 29?
Huh?
29. Page 29.
Yes. Both Gauras are not my lord, given evidence, my lord, not proof, my lord. But the school headmaster was given, my lord. School headmaster was also given evidence.
Where is
my lord.
that? Which school certificate?
Page 50, the evidence, my lord. Before this one, page 50, annexure 9.
Annexure 9.
My lord.
Annexure 9 is the okay.
Deposition, my lord. By the headmaster, my lord. Gauras are not given evidence, my lord. So this is that was the problem, my lord. And opinion was given that some names or some mistakes are there. my lord. Other evidence is page 45, my lord. Written, my lord.
Yeah, it
Mr. Sharma,
Lordship. Too many discrepancies are there, Lordship.
page 60. There are 16.
The party has stated that in this regard, he has exhibited exhibit and it is concerning condition may have this will be returned to the justice and improve the complaints.
Can it be a ground?
No, Lord.
Now we'll just see. Come to page number 33. Not discuss about first comes first, right? Page 33. Are you at page 33?
Yes, Lordship.
What you have seen? National emblem in the certificate.
Yes.
One.
Village is also different, Lordship.
Just a minute. Then,
Yes, issued on 3/11/2016, Lordship.
and when did she pass? 31st of
In-
December 1999,
Yes, Lord.
right?
Yes,
So after more than
more than
17 years,
Yes, Lordship.
which
Yes.
itself is doubtful
Yes,
as per the earlier judgment of
yes,
the.
Lordship.
So these two counts have not been discussed.
Yes, Lordship.
Do you have that
Yes.
judgment of the
Yes, yes, Lordship.
apex court recently passed in the
Regarding-
certiorari?
Yeah, yes, Lord.
Do you have? Mr. Bora, take your seat.
Bye. 2023 SCC online.
Just give it
99.
to us.
Yes.
Sharma, online to me. Online. We do की to delay है तो है online तो है online की कंपटीशन ऊपर ना की to দিব লাগিব এসএসসি online তো এটা এসএসসি নিয়ে online তে আজ তো পুরো এটা কোর্স করে দিব তাহলে যাদের একটু না উইদাউট কিছু তো অনলাইনে আহিব তো এটা মানে কোন থাকে না এটা অনলাইন নাহে অনলাইনটো নেটত গৈ আহিব নেটত গৈ মাৰিব লগ ইন কৰিব লকডাউন 1 2 3 question question Hmm? Double it. Mr. Sharma, you go through this judgment. There is one thing particularly there in the middle of the paragraph. Even if some finding of the tribunal is incorrect.
Yes, sir.
And the court finds that the writ of certiorari need not be issued on the other grounds and other set principles of law, even if that decision of the tribunal was wrong or not given any finding. If the High Court comes to the conclusion that the reasons given by the tribunal, leaving aside that there is some other wrong in the evidence adduced by the party that cannot be corrected.
Yes, Lord.
There is a finding in that in between. Anyway, come to that. But Mr. N. Bora, counsel appearing for the petitioner. NMS Ega and London CCC for response number 1. Also heard Mr. Z. Sharma, Standing Counsel Home Department Assam for response number 6. Mr. A. Ali, Standing Counsel Election Commissioner of India for response number 3. Mr. P. Sharma, response number 5. Dissatisfied with the impugned opinion dated 11/09/2023 passed by learned member Parnas Tribunal 1 Tezpur in case number F.T. within bracket T bracket close 5496/2012, holding the petitioner to be a foreigner under the Foreigners Act 1946, were illegally entered into territory of India, Assam, on or after 25/03/1971. The petitioner has prepared this petition. Petitioner contended, it is petitioner contended that the tribunal illegally passed the opinion dated 11/09/2023 determining her to be a foreigner without considering the evidence adduced by her in proper perspective. Issue notice returnable very as such and such and such, no problem. Petitioner's responsibility to instruct copy to such and such. Petitioner shall take step for service of the date. Steps will be presented on or before 22/01/2024. For furnishing copy of the date petition in Ms. A. Gayan for the response number 1. Mr. Z. Sharma for the response numbers 2 and 6. Mr. A. Ali for the response number 3. And Mr. P. Sharma for the response number 5 of the necessary acknowledgement from them in that regard. Petitioner shall take steps for service of notice on the response number 4 by registered post office providing its collateral. Appear before the Superintendent Police Court at Sonitpur on or before 3rd October. All for the records of such and such cases. Similar matter, place the matter for admission immediately on the records.
And some protection will be given.
If we are before the tribunal.
Much.
Three border, Sonitpur, and Tenchpur.
Much.
Yes, Mr. Mazumdar.
Yes, your lordship may kindly see my additional affidavit, your lordship. In compliance of your lordship order,
Additional affidavit, when did you file? Today?
yesterday it has been tagged today, your lordship. Annexure 18, page 96 is your lordship order. Directed me to deposit 22 lakhs on or before 17/1, your lordship. Then annexure 19, I submitted the copy of the writ petition along with a order of this honorable court. And I have deposited on 17/1/24, your lordship. Receipt is there, page 99, your lordship. Thereafter, I made a representation, your lordship. The balance, I paid balance of 17,88,119. I paid for liquidate the said amount within 3 months, your lordship. This is my humble prayer, your lordship.
You are appealing for the bank?
For the net fee, lordship. Net fee.
The net fee.
Net fee. Lordship, what has happened is that, Lordship, earlier the petitioner has approached this honorable court by filing a writ petition, whereby he have assailed the honor e-auction sale notice, along with host of other issues. Lordship, since there is a statutory remedy of appeal, honor, this honorable court directed the petitioner to approach the learned tribunal under section 17 of the SARFAESI Act. In the meanwhile, Lordship, the sale that has been conducted by way of auction sale on 5/5/2023, that has been confirmed, Your Honor, and the sale certificate was issued in favor of the auction purchaser. Once sale certificate has been issued, Lordship, the property has been vested in favor of the auction purchaser, and he became the owner of the property. In fact, the petitioner, Lordship, approached the learned tribunal. He assailed, Lordship, the various actions taken by the Your Honor Financial Corporation under the SARFAESI Act, as well as the Your Honor auction sale, Your Honor certificate, Lordship. The learned tribunal, Your Honor, after hearing both the parties, Your Honor, dismiss Your Honor this SARFAESI application by order dated 13/12/2023, Your Honor. That has been annexed by my learned friend at page, Your Honor, operative portion at page 88, Your Honor. If the petition is aggrieved by that order, Your Honor, he have a statutory remedy of appeal in the DR 80 Kolkata, Your Honor. On the count of alternative remedy, Lordship, my respectful submission is that this writ petition is not maintainable. And apart from that, there are various rulings of the Honorable Apex Court, Your Honor. But the Honorable Apex Court has stated that there is a statutory available. A borrower should resort to the statutory remedy.
When the sale took place?
Your Honor, the sale took place, Your Honor, on 19/6/2023. Your Honor, I'm furnishing the copy of the sale certificate, Your Honor. Page 53, Your Lord. 5/6/2023. No, Your Honor, 19/6/2023 is a sale certificate, Your Honor. Yeah. There is a sale certificate. Auction took place on 5/6. Auction took place on 5/6. I deposited on 6/6, 25 lakhs. They have issued me no objection. There is that annexure 8, Your Lordship, page 47. They allowed me to sell my machineries and deposit 25 lakhs. Accordingly, they accepted and issued NOC. And after selling my machinery, I deposited on 6/6. Then, Your Lordship, I made an application, Your Lordship. Unfortunately, that order I have got today, Your Lordship. I have filed an IA 411/2023 before the learned tribunal. And the learned tribunal, by order dated 3/7/2023, was pleased to pass status quo, Your Lordship. So position remain with me, Your Lordship.
though auction took place, sale certificate were issued, but as I have paid in the meantime rupees 25 lakhs, the NERFI have issued me no objection certificate. That is page 48 of the writ petition, Your Lordship. And thereafter, Your Lordship, as per Your Lordship order, I have deposited on 1720 lakhs. So only 17 lakhs.
Well,
odd.
Mr. Majumdar, we
Yeah.
made an inquiry whether a sale took place. You said no, the position is with you. You said very well. And we remember that fact. That is why we have asked you to deposit.
No. Sale took place. Position was
Lordship,
with
Lordship
me.
petition is misleading this honorable.
No, not misleading.
Lordship, we have taken physical possession of the property way back on Your Honor 23/8/2022, Lordship.
No, that
In
is
fact,
there.
physical possession.
See,
that is
And
physical possession.
Lordship,
Listen.
Lordship may kindly
Listen.
Lordship.
That you have taken physical.
Yes, Lordship, physical possession.
That is true.
True.
But what we wanted to know from the petitioner was that whether the sale took place
Yes.
on 5th of June 2023 in terms of the sale notice of page 53.
Lordship.
At that point of time, submission was made on behalf of the petitioner. That position is still, there was nothing about the sale.
Sale was there, Your Lordship. Position with me. I have
Where you
submitted.
have stated in the petition that the sale has already been completed. Have you said so? Which paragraph?
Sale took place.
Where you have
Auction
said,
took place.
Mr.
But
Mazumdar,
position is still with me.
where is that in the writ petition? You have said it was undervalued.
Yes,
That-
I have stated that it was undervalued.
And then where you have said that the already sale took place.
There is admitted fact, Your Lordship, sale took
Now
place.
you are saying.
Now,
on
I
that
have
day,
stated, Your
see,
Lordship,
basically, on that day, we have discussed, we have said there are orders.
no, Your Lordship, perhaps
We
there
have
may be
clearly
some
remember-
communication here. I have stated that sale took place, but
Now
position
you
is
cannot
still with
change.
me.
It is in the, it is recorded format, as you know. There is a camera here,
Yes, Your Lordship.
right?
Yes,
If
I
you see, you
again,
will be in trouble.
I again reiterate,
First
Your
of
Lordship.
all,
I may be wrong in
we
communicating.
have said whether sale took place, we ask you, we said no. And position is still there.
Yes, position with me. Sale
The
took
reason
place.
for that, the sale was to take place on 5th of June 2023.
Yes,
It is
Your
very
Lordship.
much in the particular annexer.
Yes, I have annexed it.
And we ask you, we
I have
ask
not-
you specifically whether sale took place or not. You said no, position is with you.
Sale took place. I have also annexed the
Now-
tribunal order, Your Lordship. Tribunal order also speak that sale took place. How can
We
I
have asked
support?
you-
Tribunal order is, I have annexed, Your Lordship. There it has been clearly stated auction took place. Auction took place, Your Lordship. But I have stated that position is still with me. The prime concern is there to get the money. I am ready to pay, Your Lordship.
Lordship allows Lordship.
If Your Lordship permit me for a moment.
Just a minute. Earlier on 12/01/2024. We passed an order directing the petitioner to deposit an amount of rupees 20 lakhs with the respondent net fee on or before 17/01/2024, specifically observing without entering into the merits of the case. Mr. Majumdar, learned counsel appearing for the petitioner, placed before the court that pursuant to the said order dated 12/01/2024, the petitioner by demand draft number 985507 deposited an amount of rupees 20 lakhs with the respondent net fee, Silsar branch, on 17/01/2024 and obtained a written receipt in that regard by receipt number 3289 dated 17/01/2024. To which the learned counsel for the respondent MP, Mr.
G Das, Lordship, it attends.
has no objection. It is placed before the court by Mr. Das, learned standing counsel, NP, respondent NP, that pursuant to the cell notice pursuant to the auction sale notice under the Surface Act 2002 with regard to the property of the petitioner, possession of which was taken way back on 21/03/2022. Auction took place on 05/06/2023. And sale certificate of the property mortgage, property measuring 1 kotha 8 chatak and 8 kotha 8 chatak, forward by Doug number 370 and 371 of second RS Patta number 87-1/3, measuring total 10 kothas of second RS Paragona PARGUNA dash Chatla CHATLA Power HAWR under Silpuri SIL CWORIE grant of Silsar Revenue Circle, the district of Silsar, along with civil structure standing therein, has been issued on 14/06, 14 or 19,
Lordship, sales certificate
19/06/2020.
19, your lordship.
19.
Mr. Majumdar, sister has pointed out there are 13 of your writ petition at page 10. We found that the petitioner has an alternative remedy by preferring an appeal before the appellate forum, concerned appellate forum, regarding the redressal of his grievances particularly the e-auction sale notice under the SURFACE SRFA 2002 with regard to the property of the mortgage property of the petitioner and the order dated 13/12/2023 passed by London Presiding Officer, Debts Recovery Tribunal, Guwahati,
The field out detail you don't know.
in his SURFACE application dated 13/12, rejecting his SURFACE application being SA number 81/2023. For the reasons above, as the petitioner is having alternative remedy, sufficient efficacious alternative remedy prescribed under the SURFACE Act 2002, we are not inclined to interfere. Not inclined to accept this writ petition. And accordingly stands dismissed, being not made.
Your lordship,
Deeply of myself.
in the IA there was a status quo order, your lordship. IA 411, there was status quo order 37/2023, your lordship.
Where is the I?
IA, unfortunately, I have got it today, your lordship. Your
Where I?
lordship, their prime concern is to recover the loan amount, your lordship.
Where is the I?
I am
What?
giving your sorry, I lordship could not get it print out, your lordship. There was a status quo order, your lordship. And give you.
As you
Your-
know, if
your-
the main case,
Your lordship, for the moment, your lordship, let's forget about the procedure, your lordship. Their prime concern is to secure, recover the loan amount. 62 lakhs odd was there. Even after auction sale,
that you can pay before the appellate authority.
for a moment, your lordship,
We are not inclined. On
Your
that
Lord-
day itself, we discussed, but considering.
I have
the fact
already deposited 45 lakhs, your lordship.
That you can
Only
please
17 lakhs is
prepare an
remaining, your
appeal.
lordship.
Prefer an appeal
That
immediately.
I am also ready to pay, your lordship.
That day itself, we were supposed to dismiss, but since you said that there was no sale, we
No,
consider.
I have, perhaps I may be wrong, your lordship.
Para 13, that's the remember, we have remembered everything.
There is some
That is the
technical.
reason we have asked you to deposit 20 lakhs, otherwise.
Yes, your lordship.
Had
And I
there
have
been
come,
a sale, had there been a sale, we would not have done that.
it has been stated that sale has not been finalized. That means auction took place, your lordship. It may be interpreted.
Sale certificate has been issued
Sale certificate has also been issued,
So that means
but
what?
position is
The
still with me, Your Lordship.
person-
Only symbolic position.
Prefer an FE immediately.
Deeply obliged, Lordship.
Then tribunal, I may withdraw, Your Lordship. I will fight in tribunal, Your Lordship.
Do that.
I have deposited at Your Lordship direct 20 lakhs, Your Lordship, by securing a loan from private establishment, Your Lordship. That I may be allowed to withdraw, Your Lordship.
Lordship, he still have a dues of round Lordship 25 lakhs Lordship even after selling the mortgage property. Lordship, there are other mortgage property because his dues will be round 5 lakhs. So we may not resort to other mortgage property if he pays the remaining on a 5 lakhs of his dues after exhausting that.
I am ready to pay. I have also made a representation. Kindly grant me 3 months time to pay the remaining balance.
Regarding the taking back of rupees 20 lakh deposited by the petitioner on 17/01/2024 for the respondent net fee. The petitioner may raise the issue before the concerned appellate forum as we pass the said order without entering into the merit of the case. Yes, next.
Deeply obliged, Lordship.
Yeah, please, Lordship. My lord,
Yes.
My lord, the petitioner exhibited 12 number of documents, my lord, including the voter list of 1966, 1970, 1975, 1985.
Where is the link document? Which
Link documents, my lord, 1997 voter list there, page 40, my lord. 40.
Page 40.
Page 40, my lord.
Hmm.
Rusmat Ali, my lord, is the father of the petitioner. Alexan is the mother of the petitioner. Saiful Islam is the petitioner, my lord. He is the petitioner in this case. That, my lord, the tribunal, my lord, discuss the documents, my lord, except these documents, link documents, my lord, 1997 voter list. And my lord, he exhibited, my lord, Jamabandi copy of land, my lord, and school certificate also, my lord. And the headmaster of the school was examined as DW2, my lord. And my lord, the imping opinion at page 80.
Mr. Ahmed,
My lord,
page 34, page 32.
32, my lord. Isabali box, my lord, he is the paternal uncle. Rusmod box.
Your
Rusmod
projected
box
father.
is the father.
Rusmond Box, 1966, he was 44 years.
Yes, my lord.
So his-
Age discrepancy is there, my lord. That is discussed in the WS.
1920-22, right?
Yes, my lord.
So as per this, his birth year is of 1922. Page 19, page 34. So 1970 voter
34,
list,
same age, yes, my lord.
same is, so as per this 1926.
That is a admitted fact, my lord. Some name discrepancy and
Then
age discrepancy is there.
somebody in the year 1975, Rusmot Ali, because all this time it was Rusmot box.
Box, yes. That
He
is
has become
discussed in the
Ali.
WS, my lord.
Now Jalil
Jalil is
then
the
he
grandfather.
was 49 in 1975, so his date of birth is 1926, remain as in 1970. Then after 1975, it is in 1985. There is no voter list for 10 years. There is one Rusmot A and one Nurul. Now, here
They
is
have,
19
my lord, all the
age is
voter list, my
69.
lord.
Now, if it is 1969, it's, he is 69, then he was date of birth here is 1916. Right?
My lord.
Then comes after 1985, 1997. One Rusmot Ali from Box, he has become Ali.
Box and Ali. my
Then
lord,
Alexan, it is not Aleka Bibi. And husband is Bepari
Alika
Rusmot.
Zan Bibi, my lord. Alika Zan, here, Alika Zan. Alexan.
Come to page number 32.
Alika. Yes, my lord. Alika Banu Bibi.
So,
my lord, these are discussed in the WS, my lord.
no, that's the reason.
That is, my lord.
You cannot say, you have to, if you are accepting this voter list, you have to, as a whole, in toto, complete. Some is wrong, something is correct. No, nothing like that. Then why after 1985 in 1997? What happened in between?
Between this period, my lord. He can produce the voter list, my lord.
That is up to
But-
you. If you have not
But
produced
all the
it, is up
voter
to you.
list, my lord, is not prepared to produce or exhibit, my lord.
And the tribunal found that that belongs to Morigaon district. Earlier it was Nagaon
Yes.
district. That is the reason.
Up to 2020, my lord, he casted his vote in Morigaon district.
Hmm.
And in the year 2020, he transferred his vote to my lord Gulaghat. The voter card, my lord, it says my lord. And in the WS, he also stated.
Not very convincing. Let the record come.
My lord.
Heard Mr. S.A. Ahmed for the petition. A. Gayan, CGC 41, AI Ali. Response number 2 for Election Commission of India. G. MSA Verma, Standing Counsel Home Department. For the response number 3 and 6. And Mr. P. Sharma, Additional General Assam, for the response number 5. FT case number FTG/1685/2011. On being referred by Superintendent of Police Border, Gulaghat. Learned member, Foreigners Tribunal, Jorhat. FT case number लिखित. Impugn opinion 29/11/2023. Declare the petitioner to be a foreigner and the foreigner 46. To illegally enter the territory of India, Assam, on or after 25/03/1971 from the specified territory of Bangladesh without file this petition from 10/01/2024. Appear before Superintendent of Police Border, Gulaghat, on or before 3rd of February. All for the record. steps on or before 22nd. Steps of the respondent number 4 by raised opposited.
Obliged. May I please, Your Lordship?
Yes.
Lordship, impugn opinion is at page 101, Lordship. Where the petitioner has exhibited NRC of 1951, which
Where is the
contains
link document?
Lordship, Kabin Nama, Lordship, that is page 57, Lordship. Vernacular is
Who
page,
proved the same?
Lordship.
Who proved it?
Lordship, it has not been proved, Lordship.
Then,
The step was taken, Lordship, but the issuing authority did not appear, Lordship.
then what remains?
Lordship, tribunal would have issued summon, Lordship, but without.
So what happens? If you do not prove it, it is your document, right?
Yes, Lordship.
Your evidence. Raised any other document?
Lordship, governance certificate.
Where is it?
Page 62, Lordship. It has been proved, Lordship.
Come to page number 100.
Yes, Lordship.
Read the third line.
মই দ্বিতীয় পক্ষক এই প্ৰমাণপত্ৰখন
দিয়া সময়ত
প্ৰমাণপত্ৰখন
দিয়া সময়ত
দ্বিতীয় পক্ষৰ 2019 চনৰ ভোটাৰ তালিকা চাই দিছো। পুতলাটাৰী গাঁৱৰ মুঠ জনসংখ্যা 4,516.
So, not on the basis of any record, only on the basis of the voter list of 2019. Where is the certificate?
It's 62, Lordship. Vernacular 63.
the statement of the village headman, DW3,
Yes, Lord.
whether it is basis of any record or basis of his knowledge.
Lordship, it has not been mentioned, Lordship, in the
Not
statement.
been
Lord.
mentioned.
Yes,
Now,
Lord.
when this particular witness, Kambura, became the village headman, 2000?
He deposed Lord 2023, Lord.
No. When he became the village headman, when he became the Kambura,
Lordship,
at
he,
page 99.
yes, Lord, 2004, Lord, 2008, Lordship.
2004 should be, because the Assamese is 2017 on the other side. Now, if it is in 2004 or 2008, whatever, when the Procedural got married,
In the year 1993, Lord.
so he was not the village headman at that point of time.
Yes, Lordship, that is there.
So how he can made such submission before the tribunal? It has his on the basis of his knowledge,
Yes.
not on the basis of record. If it is materials are on the basis of knowledge, whether it has to be accepted. Tell us. He was not the village headman in the year 1999 or 2000. It got married when? 2000?
1993, Lordship.
1993.
Yes, Lord.
So, in December 1993, she got married. Whereas he was the village headman only from 2004. How will you accept?
Lordship, since the Gaura is also, if I am not wrong, that he is also a government servant, Lordship. So, Lordship,
maybe that is the reason we are asking you whether this has to be from the knowledge or from the record.
Lordship, that is whether it is on the basis of record, that is not there, Lordship.
No, from his statement you have to tell us.
Yes.
He was a village headman from 2004.
Yes, Lord.
If he is a village headman from 2004, there has to be some record with him from 2004.
Yes, Lord.
The proceeding got married in 1993. And that
Yes.
time he was not the village headman.
Yes, Lord.
So,
Lordship, the government leader also did not mention a question about this.
question of thing is, just see where from what is said. Read the first paragraph.
এই গোচৰৰ দ্বিতীয় পক্ষ ৰূপ বানু নেচা পুতলাতাই গাঁৱৰ মৃত চামানুদ্দিনৰ ছোৱালী হয় বুলি মই এখন প্ৰমাণপত্ৰ দিছো। এক্সিবিট 1 হল সেই প্ৰমাণপত্ৰ এক্সিবিট 1 আই মোৰ চহী। দ্বিতীয় পক্ষৰ বিয়া পাকাবেতবাৰী পাম গাঁৱৰ মৃত হাৰান দেৱানৰ পুত্ৰ একাব্বৰ আলী দেৱানৰ লগত হোৱা কথাটো মই জানো।
So, he knows.
Yes.
He's aware. From where?
Lordship, since the Gaura and the father of the proceeding belongs to same village, Lordship, that is the Putla trace. No, it may be correct, Lordship.
That is means from his knowledge. Can it be accepted? That is the reason we are asking you. If it is from his knowledge, can it be accepted in the Foreigners Act? You are Mr.
Arslan.
For the petition. A. Gayan, CGC 1, AILE, Technical Commission 2, G. Sharma, Technical Council Home Department 3, 6 and 7. P. Sharma, 5. Oh. Referred by Superior Police, Border Corporate. Foreigners Tribunal number first Corporate. FT case number 312/2012. impugn opinion 17/11/2023. Declare her to be a foreigner under the Foreigners Act 1946, but illegally entered into territory of India, Assam, or after 25/02/1974. Writ petition filed on 10/01/2024. Appear before Superintendent Police Border for better on or before 03/02. Take steps on or before 22nd. Appear before the Superintendent Police Border on or before 3rd of February.
Obliged not.
Yes, Mr. Hassan.
May I please, your lordship. Lordship, the petitioner declared foreigner, post of 71, my lord. Kindly come to page 16. There is a migration certificate. There has been
16,
page 16. There is a name of my father and my name is there, my lord. Petitioner along with his father, my lord. Migration certificate.
Issued by whom?
Migration certificate issued by, my lord, issued, my lord, till signature is, my lord, option, my lord.
Signature is not there, Lord.
The signature is there, but it's not clear, my lord.
How you have proved this document?
Proof, it is proved exhibit A, my lord.
Just producing the document.
Yes, my lord. Clearly said in the judgment, my lord.
You have not received any information from the concerned authority in this regard.
My lord, this is the migration certificate, my lord, is the public document, my lord.
So, if you have been migrated,
Yes,
when
in the
you
year
have
of
registered your name,
in the year of 1964, my lord. My
when
father,
did you register your name?
my lord, that's not there, my lord.
So,
My lord,
if you have migrated, there has to be registration or not?
yeah, but it's not aware about this one. Then after, my lord, my father name has been appeared in the Bhutan list of 1970, my lord.
Your only link document is that migration certificate.
No, my
Anything
lord.
else?
Bhutan list of 1985, along with my father, my lord.
1985.
Bhutan list, my lord. Page 31, my lord.
Where is the voter list?
Page 31.
It's not certified copy.
Certificate copy, my lord.
Where? 31 is not the certified copy.
No,
32 is the certificate copy.
32 is a certified copy. Where
Yes.
is it?
No.
Certificate to be true, yes.
Ukile marat.
Who certified that? As per section 76 of the Evidence Act.
No, my lord, that is not certificate.
It is not a certificate, Lord.
But this document was exhibited before this tribunal, not exhibit C, my lord. Kindly come to the page 54, my lord. Exhibited document, my lord.
Might have been exhibited.
Yes.
Which kind of exhibition?
Without original copy, my lord, there is no exhibited, my lord.
If it is not a certified copy, how will you consider it? What else? What else? FA Assam for the petition. Remand, CSC one, G Sharma.
Record to আহিলে গম পাম।
Yeah, Ali.
এইটো উঠিলে যে হেৰি টাইপতে মাৰে।
P Sharma. Reference being made by the police border. Learned member of Finance Tribunal 7th, Sonitpur, Balipara. In case number FTTC 340/2016. Impugn opinion, class order dated 09/10/2020. The petition foreigner of the illegal migrant under the Foreigners Act 1946. Illegal entered into territory of India, Assam, on or after 25/03/1971. Filed this writ petition on 11/01/2024. After more than 3 years. Notice maintainability of this petition regarding the delay in preparing the time of its admission. Steps by Monday 22. Appear before Supreme Police Border. Sonitpur Tezpur on or before 3rd. All further records of this number FTDC 340/2006. Next steps appear before the Supreme Police Border. Sonitpur.
Obviously one.
people.
Not 2 weeks. By fixing a date, you do it accordingly. File it by 2nd. We'll consider it. 35 and 40. Okay. Yes. Monday. Monday. Adjourn for the day. The priority council for. Okay. Very particular. Mr. Mahmood, Land Council Committee. That he has been instructed to appear for the sole respondent. And he shall file the written argument for the sole respondent. For which needs some time. Prayer allowed. Based on 2nd of February, enabling both the petitioner as well as the petitioner and sole respondent to file their respective written arguments. List according on 2nd of February. Registry shall reflect the name of Mr. M. Mahmood and it constitutes Mahmood for the sole respondent in the contest.
From production list, item number 1.
Grupo me lo dice.
So after hearing both the parties, the government sided, and the delay has been condoned, 165 delays has been condoned, and the review petition will be numbered by the registry will be directed accordingly for numbering, finding force it is submission of the minutes. So accordingly, you are also directed with the main petition review petition to take steps within 22nd of this month. And the trustee is also allowed for this, perform opposite party number 5. Not justice service is also allowed. So petition is will be numbered and will be heard.
Same, please, Your Lordship. My lord, here is impugned order is annexure 16, page 76. My lord, the petitioner's grandfather was voter in 1960. Parents is voter in 1970, and father was examined. as a DW2. So, my lord, matter may be, my lord, notice may be issued in the case and record may be called for. Immediately, my lord, shifting is there, that has been explained. There is some minor name discrepancy that was also explained. And the learned tribunal has mainly said that brutal list are certified copy, not proof. Page 82, my lord. That was the main reason. Certified copy, brutal list are not required. That is an established law. Supreme Court and High Court and various other high courts.
Ali, heard Mr. Rasik, that counsel appearing for a petition. And Mr. G and MHT and Ladder CGC for example number 1. Also heard Mr. Vincent, turning counsel home. 2, 4, 2 and 4. Clearly comment some for the 3. Yeah, the 4. Impugn opinion 0504/2024. In FT case number 545/3 of the 107. The learned of Foreigners Tribunal number 1 3. In the reference being made by the Supreme Court Police Board at Foreigners 46. Were illegally entered into territory of India, Assam, after 25 to the from the specified or and filed this petition on 11/01/2024. Notice if request. Petitioner shall appear before Supreme Court Police Board to be on or before 03/02/2024. All for the record.
Develop layers.
May I please have it? My lord, include order page number 65, my lord. I have exhibited 14 numbers of documents. My lord, only 3 documents have been discussed. And my lord, 4 witnesses were examined. Only 1 witness has been discussed in this order, my lord.
You are Mr.
M. Hussain, my lord.
for the petitioner. A Gayan 1, G Sharma 2 Aru 4, Talaka 3, AI Ali 5. Very impugned final order 10/11/2023 in FT in case number FT within bracket 319/2017. The learned member furnished Tribunal 50 for better in a reference being made by the Supreme Police Court for better. The final order is 10/11/2023. Declared the petitioner to be foreign under the Foreigners Act 1956. Were illegally entered the territory of India on or after 24/03/2019. Agree by the said opinion that it 10/11/23 petitioner has filed. It is contended by the petitioner that though he exhibited 14 documents before the tribunal and adduced evidence of 2 witnesses, including her. The learned tribunal, in the impugned final opinion dated such and such 10/11/2022, did not consider it in proper perspective and also did not discuss about him. Before proceeding further, we like to peruse the records of Case number FT 319 of 2017. In original. Wherein the learned member Foreigners Tribunal 5th Court at Assam for the impugned opinion dated 11. All for the record. Are you able to produce the record? You able to produce it? Consider Mr. Z. Sharma, standing counsel from the is directed to produce the relevant records of certain facts before the court on 8th of February. As the petitioner has been declared to be a foreigner by the learned member Foreigners Tribunal people, she shall appear. Honorable. Third. Second. And on the next date of listing of the matter, along with the certificate of condition dated. The next date of listing of the matter, petitioner shall apprise the court as to when she appeared before the copy of this order to Mr. Z. Sharma, standing counsel from the Department for his necessary use. Yes, sir.
My lord, protection will be granted. My lord.
Appear before the SP board.
Most obliged.
Honor before second. Yes, Mr. Hassan.
May please, your lordship. Lordship, petitioner declared foreigner first of 1971, my lord. Petitioner, father of the petitioner purchased a plot of land in thereof in 1970, my lord. That is space 17, my lord. 17, my lord. Then, my lord, page 25, my lord, the Jabamindi copy of the said plot of land, there my name and my father name is there, my lord. Page 31, number 11, Sri Narendra Bishar is the petitioner and son of Madan. And opposite, my lord.
Heard Mr. F. Hassan, counsel appearing for the petition. A. Ganan, CGC 1, Z. Sharma, Training Council Home Department 2, 6, AIL 3, 5. Referred by the Foreigners Tribunal. No need for test. Sorry, referred by the police board. No need for test. Learned member Foreigners Tribunal 7th Sonit Road, Balibara. In case number FTTC 503 of 2016 by the impugned order / opinion dated 28/02/2019. Regulator petitioner to be foreigner under the Foreigner Act. Notice returnable by 8 weeks. The maintainability of this writ petition is filed on filed on 11/1/2024 to be taken up for consideration in its admission stage. Considering the fact that the petitioner filed this writ petition only on 11/1/2014 sorry, 2024. Pertaining the impugnment opinion dated 28/02/2019 that was passed after more than 5 years, almost after 5 years, without explaining any reasons for the same. Appear before Superintendent of Police Boda, Sonitpur, Tezpur, honor before second. Yes, Mr. Mana.
Please, Your Lordship. My Lord, Your Lordship kindly see page 44. Voter list 1966, my Lord. Carrying this voter list, my Lord, petitioner's grandmother name has been recorded. And against his grandmother, his grandfather name is Hosser. Page 44. Now, petitioner's father's name has been appeared in the, my Lord, voter list 1970. And my Lord, link, my Lord, I have exhibited, my Lord, before Learned Tribunal, page 56 and 57. Certificate issued by Staba, my Lord, and admit card, my Lord. His father's name, my Lord, Somej Uddin, alias Somej Ali. And my Lord, reference has been made, my Lord, against the petitioner Ruksan Ali, son of Somej Uddin. My Lord, I have annexed, my Lord, notice also, my Lord, page 74. And Learned Tribunal, my Lord, it has observed, my Lord, since, my Lord, Ruksan Ali, son of Somej Uddin, has been established. And, my Lord, due to some, my Lord, discrepancy in the oral evidence, my Lord, that has been, my Lord, taken into consideration.
Heard, Mr. Ivanov. The petitioner. Event CGC 1, G Sharma 2, and 3, Soldier 4, KILE 5, any reference being made by the Superintendent of Police Border Nolvari. The learned member of Fairness Tribunal number 2, Nolvari, in FT within bracket Nol 2. Case number 89 of 2021. By the impugned final order is 12/09/2020. Foreign under the Foreigners Act 1946. বুড়ো মাতিয়ান একো না চুপচাপ যা করো মাতিয়ান মই মাতাবি বোলে কোর্টে মাতিছে মাতিয়ান an illegal migrant of post 2503/1971. I prepared this petition on 10/01/2024. Notice 8 weeks. All for the records. Appear before the Superintendent of Police normally on or before 0 to 0. Take steps.
Obliged, my lord. Highly obliged.
22. 22. Punak moi ki kom. 45.
Item number 45.
45. We informed the standing council and city and
Yes, yes, I have informed Lordship. I will inform Alam Lordship and
ask your colleague to inform him. We'll take it after some time. Let their presence be here.
Lordship.
Forty-two.
May I please your lordship?
Yes, Mr. Sen.
My lord, in this case, my lord, we are appearing as my lord legal aid counsel. My lord, we have filed a review application, my lord, but there has been, my lord, delay for about 67 days in filing the review application. My lord. Therefore, we filed, my lord, an application under section 5 of Limitation Act for condonation of delay. My lord, documents were not given at the time of, my lord, the case has been handed over to us. They are, my lord, subsequently the relevant documents have been filed. That was given us later on, and accordingly, my lord, in the process, my lord, there has been delay.
You are appearing for
My lord, the review petitioner, my lord, Sudha Jain.
where
Who,
is
my
the
lord,
illegality?
filed,
Just
who,
tell us, Mr. Sen, where is the illegality in the observation made by the Honorable Division Bench?
my lord,
Whether in a read court such prayer can be considered.
fact remains, my lord. The factual report that has been submitted by the learned government advocate, my lord, it reveals,
Just tell us,
my lord,
show us any judgment of the apex court or our high court to show that such prayer can be considered in a read petition. We'll review the order.
my lord, we are against, my lord, the inaction and omission in part of the police, my lord, to investigate the matter. In respect of an FIR, my lord, that is, we have
There
filed.
is 12 hours provisions in the CRPC itself. There are provisions in the CRPC.
But my
There
lord,
are judgments of the apex court.
that is there, my lord, but
In that
220.
case, where is this clear bar? The three judges bench of the apex could have laid down the law very well.
My lord,
That such writ petition cannot be entertained at all. And Mr. Sen, in violation of those provisions where it has been in detail, it has been explained. Tell us.
only, my lord, our prayer before the learned single judge was to expedite the matter, my lord, the investigation.
Whatever,
And submit
the
report.
prayer that you have made before the learned single judge,
My lord,
as well as for division bench,
my
right?
lord.
It has been taken care of by, where is your writ petition? Have you annexed?
Yes, my lord, in the appeal, my lord, main appeal we have annexed, my lord.
Come to page number 26.
My lord, it is page 12, annexure 1.
Page 26 of your review petition.
Page 26.
Right?
Yes, my lord.
Para 20. Kindly read. Kindly read aloud. Let us also hear.
That the petitioner begs to state that she has demanded justice, but the same has been denied to her. And there is no other alternative efficacious remedy, and the remedy sought for in this petition, if granted, would be just, adequate, and complete.
Now, come to the finding of the Honorable Division Bench. The order.
That we have annexed, your lordship will find.
Right. Read.
At page 71, my lord. Third, Mrs. Sudha Jain, the appellant.
Read the start. We have considered the arguments. Thereafter, the next paragraph. Learned government advocate.
Learned government advocate has placed on record a copy of the factual report forwarded by the officer in charge of Paltan Bazar Police Station, as per which necessary steps as required under the law have been taken. During the investigation of the FIR number so and so lost by the petitioner, the disputed will has been procured and has been forwarded to the forensic laboratory Kahilipara on 7/1/2023 to get examined the signature of late Mohendra Kumar Jain. Apparently, the direction of the petitioner seeks in this writ appeal is to mold the investigation in a particular manner and to get the disputed will declared as fabricated document. My lord, that is not the prayer. My lord, manifestly, such a direction cannot be given by this court while exercising writ jurisdiction. The appellant has available to her the remedies under civil and criminal laws to question the validity of the will. Otherwise, also, the matter is under investigation of the police, Paltan Bazar Police Station. It is expected that the investigation of the FIR shall be expedited. If it at all the petitioner is desirous of seeking any injunction on the use of will, should have to approach the civil court concerned. With the above observation, we do not find any merit in this appeal, and hence the same is dismissed. Now, my lord.
Look at your prayer at page 27 and 28.
To expedite the investigation in respect of Paltan Bazar Police Station number so and so under section so and so, to take original will in the name of Mohendra Kumar Jain from the accused person named in the Paltan Bazar police case number so and send it to the laboratory to match with the actual signature of the testator. to investigate into the fraudulent bank transfer made by the accused named in the Paltan Bazar police case number so Paltan Bazar PS case number so from the savings account of SBI account number so lying in with SBI Fancy Bazar in the name of the petitioner's deceased husband, Lane Mahendra Kumar Jain. And upon cause or causes being shown and on hearing of the parties, perusing the records on your lordship may be pleased to make the rule absolute and be pleased to pass any such further and other orders as your lordship may deem fit and proper. And in the interim, it is therefore paid that till the pendency of the case before this honorable court, the official respondent may be directed to ensure that the private respondent shall not transfer, alienate, mortgage, lease, rent, or create any third-party rights in respect of the flat number so Pink Carpet, District and Road, Paltan Bazar, Marakhali, Guwahati, Assam. Now, my lord, what has happened?
Mr. Sen, learned single judge has considered the two judgments placed before him by the common advocate, as well as there is another judgment he might have heard of Priyanka Srivastava. And thereafter, also the learned single judge considered the aspect at 156.3 of the CRPC. The Honorable Division Bench has considered those aspects and found that there is an alternative efficacious remedy for you, and the prayers made in this writ petition, cannot be considered. We are not interested to consider your prayer. Ideally, you withdraw, you dismiss your review petition straight away. We will condone the delay and dismiss the review petition, as there is no ground on that.
My lord, there is an, my lord, there is an.
You have the provision which the learned single judge has provided in this judgment, and that has been upheld by the Honorable Division Bench.
That is there, my lord. I agree. But my lord, merely because there is an alternative remedy.
You have filed a FIR, it is registered. The High Court will not be a part with that, how to conduct an investigation. The superintendent is always there. Section 156.3 is there. And further, the Honorable Apex Court, in the case of Sakira Basu, has always said, which has been followed in the subsequent judgment, that the magistrate has the power to supervise the investigation. It is not the writ court to pass any order.
My lord,
we are not interested, Mr. Sen.
My lord, but what we find, my lord, from the
We straight away dismiss this review petition or you withdraw. It's up to you. You should go through the judgment of the Sakira. Have you ever gone through? Or Priyanka Srivastava?
I will, my lord.
If you have not gone through, then don't make this submission.
My lord,
and this, the Honorable Single Judge as well as the Honorable Division Bench has rightly considered the aspect. At least not interested here. The writ court has many other aspects to look into. It's up to you now.
My lord, will your lordship grant some time to satisfy your lordship?
Question of
that
satisfaction
because,
doesn't arise here, Mr. Sen.
my lord,
Law is well settled. We cannot go beyond that. You should go through those three judgments. Two are cited here in the single judge's judgment, and one is Priyanka Srivastava. Go through and tell us whether this petition can be. And we do not find any such illegality in the order to review the matter. Review there has to be an apparent error in the face of the record.
yes, my lord. That is what I am trying to submit, my lord.
It's not a civil matter.
No, my lord.
So,
my lord,
you want to go through those judgments, you can go through, we can give you time, but we are not inclined to consider this aspect. Okay,
my lord,
we'll have it on 7th of February.
I am obliged, my lord.
Amen. Who is appearing for NCT?
NCT, yes, sir.
I was not here on the first. I was not here in the first call, my apologies.
Doesn't matter, Mr. Bhatt.
Also, the issuing judgment is at page 323. And the
Do you know the
relevant
difference between hockey and mita?
copy and the voter pen.
There is a difference. What is that difference?
Copy and meter. জানা নেকি?
মিটা মানে সেম নেম থাকিলে
Ah.
মিটা ওকে
Ah. He knows also. Mita is that is pertaining to same name
সেম
and
ওকে ইজ ফ্রেন্ড বনাইলো
Then why do mitas are fighting?
title.
Then why did mitas are fighting? Tell us. Well,
Lots of the relevant
yes, hold
portion.
on, hold on, hold on. Take seats, both of you.
আপনি আপনার ইন্টারভিউ যখন
Raven.
full consideration of the assessment. You will become full.
I'm not even saying
Beautiful. Where is the illegal?
Lordship, first of all, Lordship, I would like to show your Lordship certain points, Lordship, before coming to the grounds, Lordship. Lordship may kindly see page 170, 96-97 session, here, taken admission. Then, Lordship, their application was rejected by Victoria PGT College. Your Lordship will find it page 175.
We understood that he could not pass. Then he took readmission or he continued to appear in the exam.
Lordship may kindly come to page 175.
Yes.
Their application was rejected on 6/12/1996. And he was a student of 96-97 for the academic session 96-97. Their application was rejected by NCT on 6/12/1996. Then again, page 176 on 13/1/1997. Next page, sir.
Then what happened?
Then page 177, advertisement clearly says that B.Ed with from NCT recognized institution. So when he took admission in Vipuria PGT College in 96-97, there was no NCT recognition. And their application was also rejected, the files were closed.
Then
ultimately he passed in the year 1999. And at that point of time,
after
also,
the rejection of the application, when this particular institution applied for approval or recognition?
That Dr. The NCT affidavit, I have also annexed, Dr. Ultimately, the recognition was granted in 2000.
When did they apply?
NCT application.
Because earlier applications were rejected.
Yes.
You have shown 175, 176.
Yes.
Now, when did they apply for recognition? Because it will be considered as a fresh application.
Lots.
The institution have to deposit 1,000 rupees along with other documents. So when did they apply?
Lots of two affidavits have been filed by NCT. Your lots will find it page 255.
264.
264, madam.
264.
They have the first application. 27/4/1996. They have applied.
That was rejected.
264.
You have rejected on 18/10/2000 because this is 27th of April 1996. You have rejected their application on 18th of October. Then when thereafter, once you have rejected, it has been rejected. Thereafter, when did they apply afresh?
Page 268.
268 is again the same thing you have said. You have said that you have to make a fresh application. When did they make the fresh application?
Lordship 269.
269 doesn't say anything about their fresh applications.
And then your Lordship will kindly come to the affidavit filed by Vipuria PGT College.
Which page?
Vipuria PGT College, Lordship will find from 292 to 295. The college itself has admitted that Lordship there was no recognition. Page 292. Page 295, Lordship, there is a specific stand by the college, Lordship itself. Regrettably, during that session, the institution did not have recognition from the NCT.
Come to page number 297,
297.
paragraph
Yes.
7.
Yes, sir. College applied again by the application dated 1/4/1998.
Mr.
Following
Alam,
which,
since it has been applied in 1/4/1998 and approval was granted only on 25/11/1998, right? For the session 1999-2000. Whether the BA degree obtained by the aviator, the writ petitioner, is acceptable or not? Because he passed in 1999. So
by that time, there is no recognition from the NCT method by that time.
true.
This period.
See, the judgments of the courts are very clear that during that period of extension, if applications have been applied and applications are pending before the NCT, right? It can be considered. Now, here is a case, in spite of filing of application by this particular B.Ed college, in 2016, it has been rejected. 1996, it has been rejected. 1997, it has been rejected. On both the occasions, it has been clarified that the B.Ed college have to apply afresh, right? So that cutoff date goes. The initial cutoff date laid down by the apex court, the next then accepted by the NCT goes. Now the fresh application has been filed, was filed by this PGT college as per their own affidavit, which you have now seen. At para 7 is 1st of April, 1998. In that case, because otherwise 96 application goes rejected, 97 did not apply, it was also rejected, because going there you have to file a fresh application. Now fresh application has been filed only on 1st of April 1998. That cutoff date already is over. It has nothing to do with this. Now the petitioner passed because initially he failed in his B.Ed examination. Read petitioner talking. Thereafter he passed in 1999, right? Now the B.Ed degree obtained by the writ petitioner in the year 1999 from this particular B.Ed institution is valid or not? Because by this particular letter of 25th of November 1998, you have allowed this PGT college, B.Ed college, to have its session from 1999 to 2000. So whether the petitioner, writ petitioner's B.Ed degree from this college is valid or not?
In that case, madam, we have filed our affidavit method. Our affidavit method, earlier affidavit, we have also stated that it is not a valid, since there is no recognition for the NCT method. In our this honorable court directed us to consider the entire case method and demanded back to past method. And accordingly, we have communicated with the government method in this respect.
No, you tell us, because you have granted their approval, the intact with 60 students for the session 1999-2000. And the petitioner passed his B.Ed degree in the year 1999. Whether it's a valid B.Ed degree or not.
In fact, madam, there is no recognition. So far as the NCT is concerned, we have concerned with the under section 14, my lord, we are concerned with the recognition method. And by that time, college is not recognized.
So, on their fresh application filed on 1st of April 1998, you have, by your order dated 25th of November 1998, you have allowed this particular B.Ed institute to have their session from 1999-2000. That is your approval, and that is your first approval. Petitioner failed.
Prior to this, my lord, we have no recognition.
Right. The petitioner passed his B.Ed degree in the year 1999.
My lord.
Whether from this particular B.Ed college, whether his B.Ed degree is valid or not.
In fact, my lord, that college is not recognized by that time, my lord.
Why?
When he has applied for admitted, my lord, in the college.
Did not he allowed for Bipura PG college?
My lord.
He passed out from Bipura PGT college.
My lord.
Then why it is the session was given from 1999?
98, 99, my lord, for the year.
No, just see, come to page 269.
1998, 97.
Just read.
297. my
You
lord,
first
granted-
read para 7 at page 297. That's the college affidavit.
They applied again on application dated 1/2/1998, following which the ERC by dot letter number 24/6/19 allow our institution to continue the system for 98/99.
Where is that?
That is at page 297, my lord, at para 7. There is
No, where is that approval? Where is that approval of the NCT?
That is at page 309, my lord.
This is your letter?
My lord, it is NCT's letter, my lord.
You accept this?
Accept.
So by this permission was granted?
My lord.
Then if the petitioner has passed his session in the year 1999, where is the illegality? He has obtained BEd, that means.
And if I may point out just one point, if permission was granted on the application, if Lordship sees the page 309 on the left hand side, that is the application number of 96. So it is basically that application was.
It is not the questionable of 96. Don't accept it as 96. Because it was dismissed, it was rejected.
Application number.
That application was rejected.
One thing is that my lord, petitioner by 1996, my lord, petitioner admitted himself for the that due to a force, my lord. Subsequently, he failed, my lord, and then again he appeared and passed in the year. By that time, NCT has recognized the institution.
So once he has failed, first of all, two things are there. The application of the particular, the Puria PGT college was rejected in the year 1996. Also in 1997. Thereafter in the year 1998, on 1/4/1998, it is an admitted fact, whether at paragraph 7 of the affidavit of the college or in this particular letter at page 309. They applied on 1/4/1998. Right? Read that later. That will clear everything.
Page 309. Your application for recognition of subsequent representation dated number dated 1/4/1998 are under consideration by the ERC. However, pending by the ERC, your institution is allowed to continue as such for the session of 98/99 within state as approved by the University Movement Board as the case may be. Meanwhile, please stand your compliance report stating the latest position with regard to the fulfillment of petitions that stated in the proposal by August 20, 1998 for further action. And also, may I point out one thing? In 98/99 also there will be an intake capacity of another 60 students. Since he was a student of 96/97, when there was no NCT recognition, and that his B.Ed course being 1 year at that particular point of time.
After when he failed, whether he took fresh admission.
Because the NCT is
since he failed. Whether he took fresh admission.
He cannot process.
Why? After failing, why he cannot?
No, yes, for filling for appearing in the examination, he may have to fill up the form. But he cannot, because there will be a separate 60 students for the year 98/99. The intake capacity is 60 students.
See, candidate fails. By the period when the particular institution was recognized, he passed out from that year. Where is the illegal?
Lordship, the Honorable Learned Single Judge has decided on this on the judgment passed by the Honorable Supreme Court in paragraph, Lordship, may kindly come to that particular paragraph. This entire case was decided on basis of this paragraph. Page 350, 351, Lordship. Paragraph 19. Only the last part of the paragraph was taken into consideration. Lordship, may kindly read the entire 351, Lordship. The Bhupendranath Tripathi judgment, Lordship. A plain reading, Lordship, may I read this paragraph 19, Lordship. A
19.
19, Lordship. Page 351, Lordship. 351.
351 is your oh, yes.
Paragraph 19. A plain reading of the provision suggests that all such institutions offering a course or training in teacher education prior to the act coming into force are entitled to continue such course or training until the application is disposed of, provided such an application has been made within 6 months from the appointed date. This condition he does not fulfill, the college. The consequence of not being able to gain recognition is the discontinuance of the course. Once an application seeking recognition has been filed by the institution within the prescribed period of 6 months, the institution is entitled to continue. So only if they have made the application.
Carry on. Read the entire paragraph.
6 months, the institution is entitled to continue offering a course or training in teacher education until the disposal of the application by the regional committee. Once the recognition is granted by the regional committee to the institution offering a course or training in teacher education, the same shall relate back to the date of filing of application. Section 14.5 read with Section 14.1 enables the institution offering a course or training in teacher education on the appointed date to continue the course or training as the case may be during the pendency of the application seeking recognition. And even in case of refusal of recognition, the course may have to be discontinued only at the end of the academic session. So, Lord, the Honorable Lord Single Judge has stressed upon the last part of that, but they have to make the application within 6 months. And their application was rejected. Remand case file করতে হবে। Ultimate judgment আছে। And your lordship judgment I have also annexed in my and lordship division bench 2-3 orders I have also annexed on the same point, lordship. The division benches also have. If there is no recognition, lordship, it cannot. And total lordship, in total lordship, there are 6 affidavits filed. In the earlier round of litigation, lordship, the director, the commissioner and secretary and NCT, all they have taken the stand that his BA degree is not valid. Then in the second writ petition against which I have filed this writ appeal, lordship, even in that case, lordship, NCT and the affidavit by Vipura PGD College and DSC Assam has also filed an affidavit, making a clear stand, lordship, that his BA degree cannot be considered as a valid degree. And NCT being the lordship, the
Mr. Alam. Page 268. Where is the earlier letter of the NCT you have just shown? 197 or something like that?
Yes.
One where it was rejected.
Page 176.
No, ये दीदी वो कोई वीडियो कुछ और ऐसे now like this. Page number 268 and 175 is the same. Read 173. Mr. Alam,
My lord.
173.
Submission or certificate for taking the petition, permission or city of for offering a post of training teacher education secretary. Respectfully, I have the honor to submit here with the application performa duplicate of teacher education intended to offer a course of secondary education secondary teacher education in this institution duly filled up by office for server of your information and interest. In this connection, it must be mentioned that this institution was founded in 1993. The state government and the authority concerned were apprised of it in due course of time. As the result of which the inclusion of the minister, education minister of the state, and some other citizens. In view of the above circumstances, expected that your honor will take necessary action to comply our respect in this regard.
So this is a letter of 27th of April 1996. Now come to 175. 175 and 268 is same. So read 175, which is more legible.
This has reference to your letter that is 175. Please refer to this letter number 15.
So this is in reference to a letter of 10/10/96 of the college. Not, as you have just read, of 27th of April 1996. Now read. This has a reference of a letter quoted such and such. Yes. Then.
This has reference to your letter quoted above. This refer to the letter number so and so 18/10/1996, in which you are asked to submit copy of the latest letter of application from the examining body within 15 days from the date of issue of the state letter. This has not been complied with. Further, you are asked to submit the undertaking on non-fiscal stamp paper by this office letter number so and so 11/10/1996, which you have also not complied with. In view of the non-compliance of the requirement, your application for recognition could not be considered and your file has been closed.
Then.
By virtue of this letter, my lord, 6/12/1996, the file closed.
Then you read.
In further,
in future,
you are to make fresh application following due procedure. Please note that if you cannot submit a copy of the letter of application from the examining body, your institution will be treated as a new one, for which the last date of submitting application in this office on 31/12/1996 and proceeding of this citation along with the NOC from the state government
has to be submitted along with the field application. Right? Now, after this, come to page 176. Here, the last date was given was 31st of December 1996. Two things have been written here.
13/1/1996.
Before that, it was in this letter of 6th of December 1976. Two things have been specifically mentioned. That since you could not permit the applications as required,
the file has been closed, and in future, the college has to make a fresh application following due procedure. That means it's an old institution, it will not be considered. That's what is the indication. And direction was given that if you do not apply, the copy of the letter of affiliation on or before 31st of December 1996 will be considered as a new entity. Right? So read the next letter.
31
See the reference.
170.
So before 31st of December, they filed an application on 30th of December 1996. Here, read.
With reference to your letter quoted above, I regret to inform you that your application has been rejected due to non-compliance with the requirements stated in this official letter number 1810. In future, you have to make a fresh application with the state form following the due procedure, which includes the demand draft of ₹1,000 and a copy of the latest letter of application from the concerned university besides other relevant.
So the application was rejected. Now, if the application was rejected, then why this letter of 1998, page number 269? Yeah. This is for 1999. You have pointed out 1998. Which one?
3098.
Which year is in 1998?
It was provisional recognition given on the application that was in 1996. Something like that. Phone number is same, file number. And top left hand side.
No. Which page?
309. 309, my lord. That is the filed by the college, my lord. No. Here it is written, my lord, subsequent representation. Subsequent, your application for recognition and subsequent representation of 1490 are under consideration by the that they have, there is a, after this, my lord, rejection order, my lord, they have subsequently submitted another representation, my lord. From this letter, my lord, to the submitted, 1498.
So on 1/4/1998, they have applied.
My lord.
Their application was for 1/4/98.
My lord.
So the session 98/99.
My lord, in respect of, my lord, their application for recognition and subsequent representation.
Representation.
If I may point out, application of 96, subsequently they have filed a representation on the basis of which the order was passed. No phrase application. Because the first time it reads subsequent representation number is 80 of 1498. That is not an application, lord, per se.
Show us that letter.
I don't have a copy of that.
Have you annexed that copy?
No, no, sir.
We want to see that later.
That probably.
Since you have not done it. So as a whole, first recognition was given to you in the year 98/99. Now tell us whether the petitioner took admission in the year 98/99.
Lordship, we have taken admission in 96/97 session. And at that point of time, the application for consideration, application is pending for consideration. And we have passed.
It was rejected. No. It was rejected, right?
Lordship, it was rejected, but after I have taken the admission, course has commenced.
That doesn't mean that it has been considered, it will be allowed.
Lordship,
so the first time the recognition was granted to this particular B.Ed college by this letter of 24/6/1998 on your application. That was of 1st of April 1998.
First representation, Lordship, application is of 1996.
Now, by which letter by which letter the NCT considered your earlier application disregarding the letters of December 1996 and January
The
1997?
only thing I could point out at this point of time is the file number that they have referred to. In entire communication is the same. Lordship, that is the file number on the basis of which they have given the recognition.
File number has to be one, but application
that-
may be different.
Lordship, if there is a press application, there is a press file number because they said the file is closed. Which was in the letter. Which
File is closed, then come back to 97. Your
97.
application has been rejected.
Lordship, but the file number.
Now, when it was accepted? After rejection, why it was accepted?
On the basis of representation, Lordship, the first time it goes to you, application for recognition and subsequent representation. Numbers for instance dated 1/4/1998. That is a representation correcting the whatever the infirmities they had in the application. That is what I could infer from the Lordship.
I don't think so.
And Lordship, also another part is what Supreme Court judgment has said and what the learned single judge has taken into account is the pendency of the application during the.
Where is your application was pending? Tell us.
It was rejected in December, Lordship. And application was made in April. Course commenced in July and August.
So
Lordship, during the comments.
So now what is the application? Tell me. If any application is filed,
Lordship,
has not been proper.
Lordship.
But if it is not a fulfilled application as required,
Lordship.
do you want to call it as an application?
Lordship, it was rejected. The Supreme Court judgment also said inconsequential of the acceptance or not acceptance, the course which commenced during the pendency will be a valid course.
When the course was commenced?
1996, July and August. An application was made in April 1996. Lordship. Rejection came in December. First rejection.
So what happened?
The course of 96,
So
97.
any candidate took admission in that particular year.
Yes, Lord. That
has to be considered.
Considered, yes, Lord. That is what the Bhupendranath Tripathi judgment says, and that has been considered by the learned single judge, Lordship. If the Lordship takes up
Read
the
the judgment.
Lordship, I'll give.
Read the judgment.
Yes, I'll just give a copy of the judgment.
No, I have an.
Read the judgment. You have annex, I believe?
Yes, it has been annexed. Page from page 345.
Same paragraph he has relied on. Paragraph 19. I'll read from the first. Plain reading of the provisions suggests that all such institutions offering a course or training in teachers' education prior to the act coming into force are entitled to continue such course or training until their application is disposed of, provided such an application has been made within 6 months from the appointed date. The consequence of not being able to gain recognition is the discontinuance of the course. Once an application seeking recognition has been filed by the institution within prescribed period of 6 months, the institution is entitled to continue offering course or training teachers education until disposal of the application by the regional committee. Once recognition is granted by the regional committee to the institution offering course or training in the teachers education, same shall relate back to date of filing application. Section 14.5 read with section 14.1 enables the institution offering a course or training in teachers education on the appointed date to continue the course or training as the case may be during the pendency of the application seeking recognition. And even in the case of refusal of the recognition, the course may have to be discontinued only at the end of the academic session, that is 1996 and 1997. This institution offering training or the course is entitled to award degree certificate as the case may be. Lord. That has also been taken into account by the learned single judge, Lord. That is laptop. You forward. No. If I may refer to the judgment, Lord, of the learned single judge.
Mr. Bazumdar. Kindly read few of the paragraphs of that judgment annexed by the petitioner here, the appellant. Read from para 14 at 349.
Paragraph 14.
The background of section 18.
Before we proceed further, is the paragraph lordship is referring
Yes,
to?
yes.
Before we proceed further, one important factor that is required to be borne in mind in the present case is that on the date of notification, all the colleges from which the petitioners obtained their degrees were recognized by the NCTE. We make
That is one chapter. That is have nothing to do with us.
Okay.
Next.
We make it clear that the candidates securing degrees from those institutions whose applications were ultimately rejected by the NCTE stand entirely on a different footing. The real question that falls for consideration is whether only B.Ed candidates who had obtained this degree after grant of recognition by NCTE, or those candidates who had obtained their degree when the application of the institution for recognition was pending, or such of those candidates who had obtained their B.Ed degree prior to the commencement of the Act on 1st of July 1995 are also eligible to join the BTC course. On an analysis of the material available on record and the submissions, the following are the various possible distinctions identified during the course of several levels of litigation concerning the issue.
Now, there are three chapters here.
Ma'am.
B.Ed candidates who have obtained their B.Ed degrees after grant of recognition by the NCT. That is one part.
Ma'am.
Second part is those candidates who have obtained their degrees when the application of the institution for recognition was pending.
Ma'am.
Obtained their degrees when their application was pending.
Right.
Or such of those candidates who have obtained B.Ed degree prior to the commencement of Act of 1st of July 1995. Now, petitioner comes under which category?
He will not fall obtain the
Any
degree.
of the category.
He does not fall.
Because if he had passed in the year 1996, he would have fallen under the second category. But in the year 1996, he failed and the recognition was rejected.
If we can come to just one line below that, my lord. Let me just put it. I'll read that sentence again. On an analysis of the material available on record and the submissions, the following are the various possible distinctions identified during the course of several levels of litigation concerning the issue. Degrees obtained from recognized institutions which have initiated courses after the commencement of the NCT Act. This is not the degree, my lord, we speak of. Degrees obtained from institutions after the commencement of the Act during the pendency of the application seeking recognition, which ultimately did not receive recognition. Degrees obtained from institutions during the pendency of application after which they have been recognized. Degrees obtained from universities and affiliated colleges thereof before the commencement of NCT Act, which have been granted recognition after the Act coming into force. Degrees obtained from universities and affiliated colleges before the commencement of the Act, which have not been granted recognition.
So,
number 5, degrees obtained from universities and affiliated colleges before the commencement of the Act, which have not been granted recognition. He doesn't fall in this category. Also.
Then he doesn't fall in any of
He
these
doesn't fall in
categories.
this category also. But my lord, if we come to the paragraph which was referred to by my learned friend, just for once, my lord, page 351, para 19. A plain reading of the provision suggests that all such institutions offering a course or training in teacher education prior to the Act coming into force are entitled to continue such course or training until the application is disposed of, provided such an application has been made within 6 months from the appointed day. I'll just pause here for a moment, my lord. Now, my lord, there is another judgment of this Honorable Court, Sopan Kumar Sinha, writ appeal number 154 of 2021, if I'm not wrong.
But there, this appointed date has been held by this honorable court to have been extended up to 1997.
That's right.
The consequence of not being able to gain recognition is the discontinuation of the course. Once an application seeking recognition has been filed by the institution within the prescribed period of 6 months of the institution, well, I'll just 6 months. Well, I'll just pause here for a moment.
This 6 months is extended.
Yes. So the application filed on 29/4/2016. I'm just trying to find out the reasoning of the learned single judge matter. What I have understood. 29/4/2016, the college filed an application. The institution is entitled to continue offering the course or training in teacher education until the disposal of the application by the regional committee. So this disposal came in December 1996.
Right.
So it was allowed to continue the course from April to December, is what I have understood. Now the writ petitioner had taken admission in July. So he had taken admission at a point of time when the
application was pending,
and therefore the institution was entitled to give the course. Once the recognition is granted by the regional committee to the institution offering the course or training, the same shall relate back to the date of filing of application. Now, this is what the learned single judge relied upon. Section 14(5) read with Section 14(1) enables the institution offering a course or training in teacher education on the appointed day to continue the course or training as may be during the pendency of the application seeking recognition.
So in December 1996,
till it was in any ways.
It was rejected in December 1996.
Now, Lordship, I'll have to read one line further, madam. And even in case of refusal of recognition, the course may have to be discontinued only at the end of the academic session. So therefore, madam, this 1996-1997 academic session, which had started, the institute was required to stop it from 1997 onwards, end of the academic session. So the petitioner's admission into that institution at a time when it was allowed to give that course is not disputed. That the institution was entitled to continue till 1997 is not disputed.
Because as per this particular line, it should have been discontinued only at the end of academic session of 96-97.
97. So now what happened, my lord? Unfortunately, the petitioner failed.
During this period, the writ petitioner could not get through the.
He could not appear in the final examination. Now, Lordship will kindly
failed.
He failed, yes. He failed. Now, Lordship will kindly see how this has been dealt with by the learned single judge.
No, thereafter,
my lord,
they have applied when? Again, they have applied on 30th of October 1996, which was again rejected in 1997.
Lordship will kindly have paragraph 17 of the order, my lord.
Factually, first be clear.
Yes. 98 they again 1996 that application which is it was rejected.
1996 they applied, and it was again rejected in 1997.
Thereafter, they did not apply for the what I have understood.
In between,
they may have made applications, but they filed a representation with regard to the rejection.
There is another issue. When they have filed the application, on the basis of which they have been granted permission in the year 1999.
Madam, if I'm allowed to read 309 once again, madam.
When they gave the recognition, see it from the recognition order.
The first recognition is 309.
That's in the before that final recognition. There you will see the application date.
Lordship, may like to have page 307 for a moment.
No, this is 3012.
No, page 307. This is 1/4/1998. application submitting fulfillment of requirements relating to the recognition of Bipuria College, your order dated 6/3/98.
What was the order?
The order of 6/3/98 is not readily available, perhaps. But not considering this aspect of the matter, what the learned single judge has held is, my lord, that since the petitioner had done a recognized course till
What was the
1997,
order passed on 6/3/98?
6/3/98 order, my lord.
Because the application of the petitioner was rejected.
6/3/98 order. That perhaps has to come from the college, my lord. Notice it, no? Six, six, eight, 10, 6, 14,
So it was pursuant to 1/4/1998.
yes, that is what
Pursuant to
appears.
1/4/1998, this order at page 309 was issued.
1/4/1998 is, my lord, an application submitting fulfillment of the requirements.
For recognition, relating to recognition.
My lord. So here, my lord, if I may read the next paragraph, with reference to the subject mentioned above, I have the honor to submit you with the fulfillment of requirement for your kind consideration. So there must have been an application, there must
There
have
was
been
a
some
letter of
objections.
6/3/98.
My lord.
If this
6/3/98 order must have raised some objections regarding the non-fulfillment of certain criteria. 1/4/1998 college tries to show that yes, these are the things that we have fulfilled. And this, my lord, I actually, although I stand for the secondary education department and the Tribunal University, the Tribunal University had faced similar situation. Where, my lord, from there I am saying that once the NCT raises the objections, it does not actually reject it at the first go. It gives an opportunity to fulfill the required criteria. This appears to be one of them, my lord. 6/3/98 and 1/4/98. 6/3/98, they have raised some objections. 1/4/98, the college
See,
tries to
if you
clear
read
them.
page 306, it is very clear.
Yes.
His application of the college was rejected. In future, you have to make a fresh application.
Fresh application. Yes.
So there has to be a fresh application.
After
File number we are
1997.
not considered.
After 1997.
So after this 1997 letter, it's very clear. They have to file fresh application, and when it was filed,
That doesn't come in.
when it was filed.
That record perhaps has to be brought in from the college. They've given half
So
baked.
they have not given the exact whether the NCT relaxed after this letter of 13 January.
Right.
So application of 30/12/1996 was rejected. Things.
Yes.
In
So therefore,
future, you have to make a fresh application
yes,
in the prescribed form,
but
following due procedure. So in future, since they have made a fresh application, pursuant to which the letter of 6/3/98 was issued, to which the college again submitted this letter.
1/4/98, yes. We take it to be that, my lord. Now, what has come up in the orders of the learned single judgment of the learned single judge is that the petitioner, having undergone the course from 96 to 97 when the institute was entitled to give the discourse, he having failed and taken an attempt in 1999, it will still remain a part of the course undergone in 1996 and 1997. And therefore, his degree cannot be held to be invalid. Lordships, kindly come to page 330, para 17.
Let's hear before we are here.
Para 15, my lord. From 15, I will read. May I read, my lord? Page 330. A reading of the proposition laid down by the Honorable Supreme Court does not make it discernible that there is also a requirement to obtain the degree at the end of the academic session itself. The Supreme Court provides that whatever course was undertaken by the students in the given year when the recognition was refused, that course would be continued till the end of the session, and whoever obtains that degree by pursuing such course, that degree will be valid degree in law. Para
So
17.
that was the finding of the Honorable Apex Court.
Yes, and then it is how it is applied to the present case. Para 17. A reading of the proposition of the Honorable Supreme Court makes it discernible that the course that was undertaken in that given year when the recognition was refused would have to be allowed to be continued, and whoever acquires a B.Ed degree pursuant to such course undertaken would be a valid degree. Nothing can be read into the proposition of the Honorable Supreme Court that the final examination also has to be passed at the end of that year itself and not later, in as much as the relevant aspect for consideration is the course that was undertaken in that given year and not the examination which was passed. The Lordships only have to test the application of this part to the case of the petitioner to see whether his passing out in 1998 would confer upon him a valid degree, a valid B.Ed degree. If the course is to be completed by 1997 and no further examinations can be held, or there can be no further examinations held for that particular course undertaken by in that institution, then the writ petitioner does not have a case. If this logic stands, then my lord, the writ petition does not, the order impugned does not suffer from any.
351.
Page 351, my lord.
Yes. There are 19.
My lord. Para 19. A
Third
plain,
line. Third line.
the consequence of not being able to gain recognition.
Listen. A plain reading of provisions suggests that all such institutions offering a course or training in teachers' education prior to the act coming into the force are entitled to continue such course or training until the application is disposed of, provided such an application has been made within that 6 months has been extended, so nothing, from the appointed date. This appointed date has been extended.
My lord.
The consequence of not being able to gain recognition is the discontinuance of the course.
My lord.
So, in December 1996, there was an information given to the college that their application has been rejected. So, the course that was initiated in 1996 academic session has been discontinued. Next.
Only at the end of the academic session.
That will come later.
My lord. Once
an application seeking recognition has been filed by the institution within the prescribed period of such and such, the institution is entitled to continue offering a course or training in teacher education until the disposal of the application by the regional committee. So, the application was disposed of in December 1996. Now, once the recognition is granted by the regional committee to the institution offering a course or training in teachers' education, the same shall relate back to the date of filing of application. So, once the application is filed, that means once the recognition given, it is from date of the filing of the application.
Right.
Now, here in this particular B.Ed college, it was rejected in 1996. Yes. Then subsequently they have filed fresh application, maybe in 1998, because it was rejected in 1997. Maybe 97, maybe 98, but what it appears to be 1998. So, relates back to date of the application.
Yes.
So, sometimes in the year 1998, some provisional sanction was made. And it will relate back to the date of application. Because in the 1996 rejected, reiterated in the letter of 13 January 1997. It has been rejected. They have to make a fresh application. After making the fresh application, question of filing any such application during the extended period.
No, the issue remains that when an application was already filed, this will, what has filed from Lordship
Application
will
was
tackle-
filed, then rejected. Question ends there.
It ends
They
there.
have, they have
So
to
now,
file
whoever,
fresh application.
whoever took an admission in 1996,
Don't
97.
come to that at this stage. Read one by one, block by block.
Madam. The
Had
98 it has been.
had one application filed in 1996 during the extended period, and it was considered in 1998, their application. So it will relate back to 1996.
Yes.
But in this case particular, the application was rejected.
Yes.
And by 1997 later, it has been clarified that
as a fresh
application.
Fresh application, not
And
as
their
an
recognition
existing.
was given in the year 1998.
Yes.
So relate back to that from the date of filing of the application.
Yes.
It is not relating back to 1996 application because it was rejected.
Correct.
The college authority here is totally silent when they have filed the application. After filing of the application, because in the 1997 later it was clarified, you have to give in the proper format with everything. They had given. They had given. And there are some discrepancies were found. So NCT again in the first part of 1998 April, they have asked. And accordingly, on 27/4/1998, the college authority has again gave the details. Considering that aspect, the NCT has given the recognition for the intake of the 98-99. It is up to them to decide. So relating back to the application is of 19, cannot be of 1996. It has been rejected. Now, the second part which you are saying or he is saying is that the course has to be considered till the completion of that particular period. That is the last part.
Yes.
The completion of the period is over in 1997. There is no denial.
Yes.
That was the reason in a case where the application affirmed by the or relation giving the sanction or the recognition given by the NCT may be of a later date, maybe of 1998.
But it will go back to 1996.
That will go to the course of 1996. For whom those applications were pending. But here in the case of this particular college,
it was rejected.
It was. So fresh application was to be filed and it will relate back to the fresh application, not from any other application.
What I had understood.
How will you, because things are like this. Once the application has been rejected, what is the next? Will the candidates who have
already
taken their course for a particular year and that period has not been recognized?
Well, that has been settled by the Honorable Supreme Court.
Right.
That
now
the
that
past
is out. They have to, that is why the court found that there are various students. They have taken admission and the matter was pending.
Yes.
That is why they said related to the date of the application.
Yes.
And the course means the entire course of the academic session. For this college, this was for the session 96-97. There was question of recognition was not there. It was rejected. They are supposed to file the fresh application. When they have filed the fresh application.
90.
Now, when they have filed this application, that will be the date from which this thing will commence. From this letter of 27/4/1998, you will see what is banking upon the council for the colleges that file number is of 1996. That is not the issue. This is when they have filed the application.
No, that is
after the 13/1/1997 letter, it is very clear they are supposed to file a fresh application in the proper format, giving everything, including the approval given by the university.
Right. The understanding, my lord, of the learned single judge until this point of time, my understanding was that 1996-1997, when the course is said to be, it is to be rejected. Whoever has passed within 1990, whoever has undertaken the course of 1996-1997,
December, they're out. They have passed.
But that has
Till the order has been passed.
What perhaps the Supreme Court had my understanding that the academic session will come into end in July 1997. Rejection comes in 96, but the course will continue till 97.
Course will continue.
Course will continue. So the writ petitioner was a person who continued his course till 1997.
Yes.
So he was under the recognition period. the deemed recognition, if I may say so, that because the rejection came in between.
Whether the Supreme Court has gained recognition to that thing by reading that particular paragraph.
That section 14.5, that part covers it, my lord. The till the rejection, it is only if a rejection comes in, it will only be that particular academic year has to be completed, and then you cannot further do any more courses unless you get a recognition.
Petitioner did not pass in that year.
So that was what was considered by the learned single judge, saying, since he did the course, the year of passing will not be material. Lordships will only test whether that logic is correct or not.
You think
That is what I was trying to place, my lord.
tell us, is it possible?
So, my lord, if a person undertakes a course in 1996 and 1997 and he fails, the examinations are held by the university. It is not done by the college. I'm just trying to place how we can build it. So if the university holds an examination, a backlog examination for the persons who have undergone a valid course in the year 1996 and 1997, the examination is held in 1998. Would it invalidate the degree, number one? Number two, my lord, if for some reason examinations are not held at the end of the session of 1997, for whatever reasons the examinations are delayed and the examinations are held by the university, which does not need a recognition from the NCTE, and the person passes out in 1998, then would he still lose the validity of the degree? This happening in the years 1996 and 1998 or prior to 2001, if you may say. This long period of service, these men have been carrying their degrees along with them. As of today, invalidating that would, I do not, because lordship will find perhaps at page 76. At page 76, my lord, how the certificate has been given. Page 76 for a moment, my lord.
This judgment date of which date?
5/12. 5/12.
Upendranath Tripathi.
Upendranath Tripathi came in 2010.
So it will have effect of 1999, or it will be giving a retrospective effect.
My lord, that is what it has further gone ahead to say, that all persons who had acquired degrees prior to coming in of the act and also after coming into the act on such a situation, they will all be covered, is what this judgment says. My lord, this is what the judgment tried to take into account. The NCT NCT Act being enacted in 93, being enforced in 1995, and extensions being given in 1997 had created chaos all throughout the nation, my lord. And that is why the Honorable Supreme Court had to go into all these details and give this benefit to those recognized and unrecognized parties. It does not relate to, my lord, the present situation. It relates to that situation which stood then when the act came into being, 1997. It tries to decide that matter. As of today, my lord, there is no doubt. Once it is rejected, course cannot be continued. That is
page 350.
My lord.
Read para 5.
Para 5. Every institution in respect of which recognition has been refused shall discontinue the course or training or teacher education from the end of the academic session. Next, following the date of receipt of the order refusing recognition. So when the order is received, that session is the last session, is how I read it, my lord. So therefore, 1997, 1996, 97, perhaps Bipuria College cannot be said to be running an illegal course. But here the issue is the person passed out in 1998. What? 1999. How the interpretation has to be done in his case is, my lord, the issue. If lordship says that page 76, lordship will find the course is given as
Mr. Das, how you are affected? Ultimately, it is the director who will hear you.
Yes.
Also, my learned friend is submitting beyond the affidavit. They have filed 4 affidavits. Their affidavits are very
I am
clear.
an officer of the court. Affidavits are filed by directors.
Affidavit is
not
filed
by me.
taking a very specific stand. and they have defended. Lordship may kindly see page 325. Page 325 of the Larned Singh order, Lordship. The respondents in the secondary education department, Assam, in the writ petition takes a stand that the decision arrived at the communication dated 16/3/2021 is a right decision, that the B.Ed degree would not be a valid degree. Mr. G. Goswami, Learned Counsel for the Bipuria PGT College, also agrees with the view of the secondary education department. They have also filed an affidavit. And Lordship has read paragraph 19 of the Bhupendranath Tripathi judgment. It is very clear. Those colleges who had made application within the period of 6 months, they had met their application, they had made, but their application was rejected. So end of the academic session would be 96, 97 only.
I think it is better.
And I have given other judgments also, Lordship, which most and NCT Act, Lordship, 14, 15, 16, and 17 is very clear. I have also annexed the NCT Act. Lordship, my submission is, since NCT is the regulatory authority of B.Ed degree, and since NCT has taken a specific stand in 2 affidavits filed in this proceeding, Lordship, that the B.Ed degree of the respondent number 7 is not a valid. So the Learned Single just could not have gone beyond by interpreting, Lordship, that particular paragraph, because that particular paragraph also says that application would have to be made within a period of 6 months. Very clear.
That has been extended.
Yes, even the period of extension does not cover him.
Why?
Yes, 18/8, the extension period was 18/8/1997.
Application was extended, it was accepted.
1997, it was extended in 18/5/1997. These applications were made in for the year 1996. It was made on 1/4/1996.
Period was extended.
In fact, it has been pointed out at page 124, NCT says we cannot decide whether you have it or you don't have it. I do not know.
No, that is the earlier on the litigation. The second affidavit they have filed.
Mr. Muzumdar, when the apex court did not say that the candidates who took admission in that particular year in which the recognition was rejected, can we, of our own, expand that period?
That also had come to my mind, and I had tried to think it over in the manner which I just placed, my lord. That the person undertakes a course.
Because if you read the previous paragraphs of that judgment, they have segregated part by part by part. One of the condition was very clear, itself in the NCT's guideline, that which repeated paragraph.
Paragraph.
So it has to complete in that. That the course is considered to be. That is applicable for whom?
Those.
For those. who passed the degree in that particular year, or also will include the candidates
Completes the course, but passes out at a later date. That is exactly what is to be tested by this honorable. Because if Lordship has a look at the certificate, it says the course, this is to certify that Sri so and so was a trainee of this college for the academic session 96-97. He passed the BA final examination held at from Iman to Iman from this college conducted by the Tribunal University. Now, my lord, it will be very fortuitous. I'm trying to think on both the sides. My lord. One, you complete a course and you do not appear. You could not appear for whatever reasons. The time period is gone. There is no recognition. You are out. That could be one view. The other view would be it is fortuitous. When does the university hold an examination?
The university is holding the examination in something different. For the purpose of obtaining a PhD degree to appear in the exam in the 1998 or 98,
My lord.
he is required to take press admission.
My lord,
A failed candidate, how he appeared?
my lord, he fills up the form again as a old student or maybe as a this thing.
That old course has already been recognized.
That will be Lordship will find that the NCT recognizes
That part needs to be examined again.
Yes. And Lordship, one thing I'd like to just place for Lordship, there are two parts. One, the degree, this has been a confusion my lord, in other repetitions also, and therefore I'm placing it. But one is the degree which is given by the university, saying that you are a B.Ed from today, you have got a degree. Now, that degree, the NCT cannot question or govern. What the NCT can do is, prior to that giving of the degree, there is a course which has to be undergone. If the institution is not recognized or the course is not recognized, then the degree will also go, is what the Supreme Court says. Now, the degree comes from the university. Therefore, when the university will hold an examination is up to the university. But whether he underwent a recognized course or not. Because my lord, when we say that the CMJ University, this is one of the arguments in other petitions.
Heard Mr. Eskeda's counsel appearing for the petition appellant.
One judgment, Lordship, may I place?
Not
Now,
at
both
this
to
stage. Not at this stage. And Mr. R. Mazumdar, Learned Standing Counsel, Education Department, for the respondent numbers 1, 2, 3. You are also appearing for Dibrugarh, Standing Counsel, Education Department Assam, as well as Dibrugarh University for the respondent numbers 1, 2, 3, and 5. Also heard Mr. A. Alam, Standing Counsel, NCT for the respondent number 4. You are appearing for 6, 7. Who is appearing for 6?
None. Notice has not been issued. It's super safe. No.
And Mr. D. Decker, Learned Counsel for the respondent number 7/caveat.
Lordship, on the earlier question, Mr. G. Goswami appeared for Bipura PGD College.
Here it's an appeal. The appellant herein is aggrieved by the order dated 05/12/2023 passed by Learned Single Judge in WPC number 3166/2021, wherein he was the respondent number 7. Matter relates to the B.Ed degree of the writ petitioner, the service that of the writ appellant. Issue notice returnable by 4 weeks As such and such, no formal notice, petitioner shall serve copies of the said memo of this to such and such on or before 22/01/2024, obtaining necessary acknowledgement from him in that. The appellant shall take step for service of notice on the response number 6 by registered post with a D, providing it such and such. In addition to the above, dusty persons are filing up the response. Obtaining date, signature, seal to provide in presence of one or more. How old are you?
Lots I am 50, 55 or something.
How old is the writ petitioner?
I'm 56, sir. There are 4 years of service left. 55.
What was the in affidavit?
That is 21. 2021.
52 in 2021.
Box to
54.
affidavit.
Where is your affidavit?
He states at para 1 to be of 49 years as of today, my lord.
Where?
Of the writ appeal, my lord, in the memo of parties. In the matter of Shri Brian Bora, aged about 49 years, he said. But in 2021 also he's shown to be 49 years. But this is wrong.
Kurukshetra. Till the returnable date. The impure. In order it is conceptual. Not well on its single pitch. In WPC numbers of that. 3166 2000. Dated 5/12/20.
Just 1 point.
Or KVN economic. Not Mr. Ticket. Client counsel for the case. D deca or DK deca?
D deca.
D deca.
But if I may point out just one part, the judgment does not infringe on any rights of him to be before the director. So I pray that order may be on the judgment that the consequent of the any orders passed, subject to the orders of the writ appeal. Let the director continue with the process. We have already suffered for 2 years.
I think that is the reason we initially went ahead, but this interpretation will be required.
Lordship will fix a date.
Give us a date after 4 weeks. 15th of February?
Yes, sir. Because he is holding the post, Lord. He has been principal since 2021.
Without clarification, even if the director goes ahead, there may be some issues.
Yes.
Let it be clarified by the revision bench.
Okay.
15, we can have it also on 17. 17 February is a working day.
Saturday.
Saturday. Saturday is an odd day. Saturday is a nice day. It's a very lucky day. Okay, on 15. Returnable by 15.
Obliged.
Subject to